Welcome back. Welcome back. Ladies and gentlemen, it is your boy, the one, the only original American Dankster. It is from Danksters Intel being broadcasted from the home studio. Tyler Robinson, day 4. Man, go to americansfortransparency.org if you want more of it and you want to know what your money, your tax dollars, and the government's money is being spent on and how it's being spent to destroy your belief system, spy on you. Go to americansfortransparency.org. And we're going to be covering today day 4, but we're going to speed run through 1, 2, 3, and 4 where we ended up. There's a segment that I do want to play. Of course, I'm a big fan of Barron. I can't help myself. Barron does such a great job. I fell asleep while I was so tired. 11 hours almost, I think, of streaming, maybe longer. 6 a.m., 6:30 a.m., all the way until about 4:45 p.m. So almost 11 hours, something like that. And I knocked out early. So luckily I woke up about an hour and a half ago naturally, which was always nice. But we're going to definitely be, this is going to be a great show. So you want to stick around. We're going to probably, I haven't decided, but I think I'm going to go through and watch just straight from this stream into the hearing itself, the Tyler Robinson preliminary hearing. It's supposed to be a half day. I think I could stick around and do that. I'm not on anybody else's show today, although I do advocate to go watch anybody else if you'd like when the show starts or when the pre-trial hearing starts. So I think we'll be doing that. So you can expect to, from now, we're going to cover all the way to an hour and a half from now when the trial is supposed to start or the hearing. We will watch the hearing. I'll do my best not to pause and ask questions in my head out loud to the audience, but I might do that. So if you want to stick around for that as well, we're going to be here probably for the next 12 hours. I have a feeling it might be the next 12 hours. We'll see. We'll see. If it's slow and it's kind of doomy, gloomy, it's like, kind of boring, because there's not going to be a decision today. There's no decision rendered today. So I'll read you real quick what I copied this from Google and I sent it to a friend. It says, rather than delivering standard live closing arguments today, Judge Graf ordered both legal teams to submit comprehensive written briefings over the next few weeks. Final oral arguments are set to take place on September 1st, 2026. So 10 days before Charlie Kirk was assassinated at 10 a.m. Mountain Time, their local time. So that'll be 9 a.m. Pacific, specific, after which the judge will officially rule on whether there is enough probable cause. Because remember, this whole thing was, is there enough probable cause of Tyler Robinson to get them to trial for murder, right? So the judge will be then determining by September 1st at 10 a.m. Mountain Time this year to rule whether there's enough probable cause to send this case to a jury trial. So we will not really find anything out today. That is the case as it were. So here's where we are today. In Provo's courtroom, the prosecution put up the single most damaging piece of evidence in this entire case. That's from their perspective. I guess I'll just tell you the text messages. Lance Twiggs asked Tyler Robinson, "You weren't the one who did it, right?" The reply comes back, "I am. I'm sorry." That's a lot of what this is seemingly to be hinging upon. I did post those messages on X. Welcome if you're here. Thanks for joining. If you're new here, please smash the like button. We just do covering things with receipts. We try to show. Of course, I have my own opinions on things, so you're gonna definitely hear some of those. So if you don't want that, you might not want to be here. But other than that, we just show receipts. We talk about what's going on in today's some of the more important things. Besides, of course, I've loved to cover other things like data centers and the war and geopolitics. But sometimes right here at home, in our backyard, is some of the most important things I like to cover myself. And we're covering the Charlie Kirk assassination and Tyler Robinson's pre-trial hearing to see if they're going to get to a jury trial. let me share my screen here. Let me see. Let me pull. I was tempted to pull Sam Parker's. Everyone, the whole, like, my whole feed is just. I mean, you can see everything is Tyler Robinson here. I'll share my feed. It's literally. It's just. So Sam Parker. I don't. Is this For You page yet? Most of it is about the case. There's a lot of pictures. My boy Keats, Barron. What did Barron say? Your boyfriend has been gone 12 hours. So there's a lot of people picking apart these texts. All right. I posted, I think I got them all. Let's double check here. I posted a lot of stuff yesterday. I just wanted to post stuff for the public to have. So the first alleged Tyler Robinson, Lance Twiggs images of, I should have put, of their phone's text was shown. Okay. This is that, I think that's the first one, right? Let me see. I don't know if I have them in order, but I think this was the first message. Oh, don't tell me I didn't bring my coffee. Oh no, I didn't bring my coffee. It's in the other room, ladies and gentlemen. What are we gonna do? We'll see what happens. Let me try to send a text. Babe, I left my coffee in the. I'm gonna have to. I steeped the milk creamer and it's fluffy and warm now. Maybe she will get. I don't know. She's getting ready for work. Okay. What do I do? What am I doing here? Okay. So sorry to take you on that. I didn't mean to take you on the sideshow, but that's what you get here at Danksters Intel. You get all the intel. Good morning to everybody. I hope you're doing well. Okay. So this is supposed to be a text message. Looks like, I guess this is an iPhone iMessage. 7 p.m. That still work for you. So this is coming and going to from Tyler to Lance Twiggs. This is what they're saying. Can I zoom in a little bit? Maybe I can open this image in a new tab so I can kind of go in. There we go. 7 p.m. That still work for you. So this was already in motion. All right. What's crazy is this is, and Barron covers this, and there's a whole segment of intermittent I want to cover of Barron because he does all these in a row, which I want to cover, which I think is great. But I do want to point this out. It's like when you look at him, this conversation, and we've all seen this before, we've enacted it before. There's been a lot of fun around it, but what does this person know? I don't know if I heard this from somewhere or if I thought it. I might have just heard it from somewhere and I'm parroting it, but it made sense to me. Drop what you are doing. Look under your keyboard. What? You are joking, right? Are they what are they responding to? What? You are joking, right? And then this seems like just slop thrown together. What is this exactly? I don't want to be of this like denial, like, oh, you'll never admit that this is, but it's really hard for me to understand if you're explaining it to me this way. Who these what are these? What is happening here? Why is Lance Twiggs responding to what? All these questions. You're joking, right? Went to this question. Did somebody delete something? He said he tried to delete that. Did he delete something? Maybe that's what we're missing. Maybe he did delete that. Can someone let me know in the comments on iPhone? Can you delete your message to somebody ever? Can they be deleted? And like, also, what is this? Like, did he try to break his phone or something like that? Or what? He brought his phone with him into the police. So his phone is that damaged, bro? You're a 4.0 GPA student. You're smart. You're in college. Yada, 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 yada. You're in university. And you got a phone that looks like a homeless heroin addict in 2010. For real. That's what, trust me. You could trust me on that. I'm telling you, if a junkie has a phone, which they rarely do, but if they do, that's what it looks like. So you're telling me that Tyler was junkie mindset around his things? Really asking a lot. Okay, so yes, you can just hold the message and press delete. Yes, in real time, unsend for limited time for both parties. Okay, if they've read it, can you unsend it? And also, like, he could have deleted it too. We don't know what was deleted. It's like see, when you want to look at stuff on a phone, when it comes to me, this looks like a show because you can go in. I would want to, as a developer, I would want to go and look into the metadata of the phone. None of this matters. None of it matters at all. I want to see the information from AT&T or whatever the company is that they're using. None of this stuff is going to hang me up to say, oh, because I know that both sides can delete stuff and I need to look at the data. I need to look at everything underneath, what was deleted, all the actions. I need admin, like master admin access to that phone. And I will be able to determine whatever for myself. And I will be able to tell whose phone this is, when it was created, where they got it. You know, this looks like an old ass iPhone. What generation? It looks like an iPhone 7. What are we on? 17 right now? iPhone's newest iPhone model. I think it's 17. I think I got it from my wife. Yeah, iPhone 17 Pro Max. Well, let's look at an iPhone 7. Not newest. Let's take that out. Apple iPhone 7. Hopefully it doesn't just show me a bunch of 17s. Is this this isn't an iPhone, is it? Hold on. What I'm looking at, is that an iPhone? Am I tripping? Now looking at it, this doesn't, I mean, the case is kind of, I don't know, man. I never even really thought about it. It doesn't have this circle on it. Like, you see how these have that circle? But it does look like that. No? You can't tell me that this doesn't look like that. Camera's top left. What kind of phone has a camera in the top? Is that a camera in the top left? What is that? Oh no, camera's dead center. Huh. Did they not show a number? Someone said, why no number? That's a great question. Why no number? I don't like, actually, when I'm texting, like if I were to here, I'll show you my phone. So I have well, mine's different. I have a Galaxy Fold Edge, whatever, Edge Fold. So not an Edge, it's Galaxy Fold Z. So this right here, but it won't show. It won't show. Let me see. I'm not gonna. Yeah, it doesn't actually. It doesn't show anybody's phone number in my contact here. Yeah, I don't want to. It's obviously my text, but even so, I wish I could show you. Hold on, let me see. Damn it. Yeah, I can't show any of these. I want to, but literally, you could take my word for it on Android. And this is dual screen. This is both sided. The right side has the text message thread that I have selected on the left, and the left has a list of all of these people. None of them has the name unless I haven't saved that person to my. None of them have the number unless I haven't saved them to my contacts list. Also, if I've saved them to my contacts list on my phone, and this is Android, it just shows their name. So text message with the number, I don't expect it myself unless iPhone does that. But yeah, anyways, let's keep moving forward. And that's the moment everybody seems to be talking about. There's a lot of other things in discussion. And the whole game today, I would say, is that text got read into evidence at a hearing where the defense was not allowed to cross-examine. We're also going to cover a little bit of the Lance Twiggs interview. Okay, the Lance Twiggs interview that they piped in. It's I don't know if I've yet to have found a word for it. I don't know if it's scary. I don't know if it's strange. I know it's definitely strange, but there's a few different words that need to go together on the Lance Twiggs video. They cut out 16 minutes of the pipeline of video footage. So I think it was supposed to be like 30 something minutes, and it came down to 23, maybe something like that, 21. And so we're only getting a certain amount of the footage. It was strange because they started it off. If you didn't see it, let me put a poll in the chat. I want to find out how many people were actually at the or watching the event, or watching the hearing. Were you watching the hearing yesterday? Yesterday, day 4, Lance Twiggs interview. I just want to know how many people showed up to watch. Yes, all of it. No, none of it. Some of it. Some of it. There we go. I think that works. Yes, no, I watched some. That way I know where I'm at with the audience. Okay. Again, if you're rolling in, say hello. Let us know where you're at in the chat, where you're from, where you're chatting from. Hit the like and subscribe button. Let's reset this whole thing for anybody just tuning in, because 5 days of legal proceedings is a lot. And it's been a lot for me. It's been a lot for people that I know. It's been a lot for me regarding YouTube and content creation. By the way, we're live on Kick, X, and YouTube right now. Getting all of this set up, it's been a lot. And it's a lot of information. Okay? It's a lot of information being presented. There's a lot of things that we have been talking about a lot of this stuff since that evidence perhaps has been found or come into existence. We are looking, I personally, I'll just speak for myself, I am looking at this from a lens of, well, this stuff is obviously slop sometimes, but not sometimes, actually, that's how I feel. And so I have to set aside all of that. We're talking months and months and months, 9-10 months of just opposing the narrative to watching them fulfill the narrative in real time. They are going all the way through. There was something I was live streaming with Nate. I wish I had with Valhalla. Nate is his name. Valhalla VFT is his YouTube channel. Matt from Trigger Smart and Baze, and we were all streaming yesterday. And there was something about when they show. I'm not going to show the bullets. I don't want to show anything firearms related on this channel, because they've taken down my live stream twice, and their excuse or their reasoning, was for firearm or handling a firearm of some sort. I just don't even want to risk it, so I can't show the bullets. I don't want to. I want to, but I don't want to. Anyways, I think that when you're looking at all of that, I have to pull apart all of this bias that I have, because I do have bias, obviously. I think we all probably do, if we're honest with ourselves. I try to remain neutral. But when we're talking about the ballistics, when we're talking about the, I was going to make a really good point and I went off task, I went off, anyways, about the ballistics, it's like this is what I was going to say. Now I remember. Nate, when he said yesterday, well, that's it, they're going all the way through with it, there was something about the way he said it that really hit me. It was like, oh shit, they are all in on this 30-06 narrative, and they are going all the way through. You know what I mean? It's like, it feels a lot less like getting God's honest, diehard for the truth information. Instead, it just feels like not that. I don't see how they can tie all of these things that in a case like this, you would have some evidence of the kid taking a shot or his face actually being there or something. But they've got none of that. So far, they've got none of that. The jury, I mean, the prosecution so much as said they have none of that. They assume the shot was being taken. And that's a major win in my book if I was the defense. Here, this is I'll play just this snippet. I think we all couldn't get enough of this, to be honest with you. Let me see. This one right here.
Is there any footage of the alleged shooting?
There is not, Judge.
Okay. Just want to click.
There is not. Now, I'm going to let this play. I'm going to get my coffee. I'll be right back. Give me 1 second.
Verify that. Ms. Nestor, given that additional information and anything further from defense?
No, but I think I'd like to be crystal clear. You asked if there's any portion of this video that captures, and I believe you asked of the actual shooting. There's no video of that. There is video, however, and you've heard testimony related to this, where the shooter goes to the top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired. That's as close as it gets.
And the court also...
That's as close as it gets. That's as close as it gets. Think about that. We assume the shot is being taken. Is that when he said it?
Top of the low-C building, goes out to the edge of the building, low crawls, and then leaves after what we assume is the shot being fired.
That's it. That's it. That's all you need. After we assume the shot's being fired. They wouldn't have said that. And I will repeat that probably every day until the day of this, till September 1st. God forbid if I have to do that. But it's true. I was able to get my coffee. This is a big win. This is a big win for all of us. It's a win for all of us, ladies and gentlemen. Ladies and gentlemen of the, I was going to say of the jury, but that's not mine to say. Okay, so we're going to bust out some Baron right now. There's just so many good parts. And yesterday I was watching this morning when I woke up. I was like, wow. I was trying to watch. I still haven't gotten to the end of it, to the end of his opening scenario. But I'm going to back it up to about right here. I think it's kind of it's a good portion of it. So I don't want to play too much. I'm going to try not to. Let me play this part. How about that? Let's do that. Okay, here we go. Okay.
And I say that because time is of the essence, not because I...
So this is Neiman, the lawyer that is the attorney for Erica Kirk and Kirk family, I think. I think it's all of them, the Kirk family. So I believe he's representing the interests of Erica Kirk, the children, the parents. I'm not 100% sure, but I'm pretty sure the parents. I think it's anyone regarding Charlie Kirk. I'd be surprised if the parents had a different lawyer. That'd be very telling. I don't think that's the case. If it is, and somebody knows that, please let me know. So this lawyer, after presenting evidence, they have something that they wanted to say. I posted this video on my channel as well. Baron gives great commentary I want to react to.
And I say that because time is of the essence, not because I don't want to hear what you have to say.
And he's been, if you were there all day, did I put the poll up? Let me check the poll. He was all day. He was irritating the judge, seemingly. Where are we at? Oh, yeah, 65% watched all of it. Congrats. That's great. I love to hear that. Fantastic. So you all know this guy, a little much. He's a little much, if I got to say so myself. I mean, I don't know. kind of feels like an ex-girlfriend. I don't know why. Don't hold me to it. It just feels like he's kind of ex-girlfriend-ish as a dude, you know? Just like, bro, chill. Like, we're all adults here.
I understand, but there was a lot that was just said that's just not true.
Well, so let me put this in this spot where we need to be. I understand that there's opinions, but I have to keep this to the probable cause. I don't want this to go to a back and forth.
This was a very common situation that what was happening is both the defense and the even the defense, especially mostly the defense there at the end of yesterday, were going into trial territory. They were like trying to prove wrong and confusion or sow doubt in the person on the stand. And it's like, right now is not the time for that, you guys. We're just trying to see if this is going to go to court for trial in front of a jury, and that's it. And everyone else, seemingly for some reason, is going off the rails, trying to prove everybody wrong. And so that frustration comes from the judge's enduring experience of everyone overwhelmingly they're treating this probable cause as trying to sow reasonable doubt. And that's where I think the judge was getting frustrated. Hopefully I explained that okay. I was trying to find a way to get that across. The judge was frustrated in general yesterday because people were the attorneys were taking things too far as what was supposed to be acceptable for the hearing. They were bringing in way more information. They were quoting and citing journalistic integrity and etc., where it was like, guys, this is not the trial. And I think a little of that frustration comes from that, but also the guy is just kind of annoying.
About issues that lie outside of probable cause. And I realize statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you.
That was such an annoying thing to say. Your Honor, I am almost always brief, I promise you. It sounds like now he sounds like a kid whose parents let him play PS5 or 6 or whatever we got now after he eats his broccoli.
Hear what you have to say.
Your Honor, I am almost always brief, I promise you.
But it is a very kind thing to say at the same time. I can't, it's like very cheesy, but it's very kind. It's very strange. It's just weird.
The family's not seen this video.
Oh shit, I'm not playing it.
Do you see the lawyer at the lower left laughing?
I'm pulling a Baron. I pulled a Baron.
Probable cause, and I realize statements are made and lie outside of probable cause, and I realize statements are made, and as the victim's representative attorney, you want to address it. So I will hear you, but we need to be brief. So if you can be succinct, I definitely want to hear what you have to say.
Your Honor, I am almost always brief, I promise you. The family's not seen this video.
Do you see the lawyer at the lower left laughing?
I didn't notice.
I have no idea why Utah entertains this nonsense in a very serious situation where the state is trying to kill a man. The state of Utah is trying to kill a man. The two men you see right there in the foreground, the two closest to the camera, those two are trying to put a man to his death. And that the fact that we let outsiders come in with their own lawyers and inject themselves and start demanding of the court how they handle arguments, I don't think the judge is amused either.
It doesn't have access to the evidence the state has. The state is the state, and Mrs. Kirk and the family have their representatives. There's a completely distortion of reality that was just put forth.
I sped it up a little bit. You probably need to hear it on regular, the way he talks.
Have their the evidence the state
arguments, I don't think the judge is amused either.
It doesn't have access to the evidence the state has. The state is the state, and Mrs. Kirk and the family have their representatives. There's a completely distortion of reality that was just put forth. And this is about educating anybody about
Distortion of reality. But listen
anything.
next.
This is about allowing the family to see the evidence that's been gathered after a 10-month investigation in which a father, a husband was assassinated. That's what this is about. So we ask you to please
And I understand. I get you, bro. But
allow
listen.
the family to view the video like the court has viewed in order to allow.
They're saying, because the court has said we are not going to show everything to everybody, to the audience or what have you. There's certain things we're not going to. This guy's arguing to have the family at least be able to see it.
The family to process this moment.
And so here's how I would handle it. I don't even know if this is an option under Utah law, but I would do it anyway. And I would let everybody throw a fit. And it would reveal their true motives. If I'm Judge Graf, I say, look, we don't have time for this nonsense. I've allotted 5 days. This is a complex case. There's a lot of witnesses. There's a lot of evidence. Here's what I'm going to do. The next time we take a recess, the victim's representative and any one of her guests that are there with her who she wants to go in with her can go into a side room, pull up a laptop, and watch the evidence. That way you guys have seen everything that I've seen. And if that's not good enough, I question your motives. Because you're claiming that the only reason you want it published to the world is because you want to see it.
That's what they're acting like. But when it comes to other things, no. And that's where he points out something fantastic that I had to show. And I think this is where he does it.
I'm giving you the opportunity to see it, sir. Are you going to take advantage of it or not? And see how he responds. Because I don't think it has anything to do with Erica wanting to see it. This entire charade.
Imagine if it, like, okay, imagine if it's not Tyler Robinson. And imagine if, well, yeah, I mean, imagine if it's not Tyler Robinson and there's a whole, I didn't want to derail into what I think something maybe could be, but let's just go down this path for a second. Say it's not Tyler Robinson and the people that did do it, say it's a group of people, hypothetically, allegedly, maybe, perhaps. A group of people want to know what the jury or what the judge has, what the prosecution has. The only way to see that, unless they have somebody on the inside, which maybe they do, maybe they don't. If it is even, this is all fairy tale stuff. But if they did, you would imagine they'd have somebody on the inside. We don't know who, if they do. But if they don't, where are they going to get all the information? Well, they're going to have to get it from the court, just like everybody else. The closest they can get is the family, the actual victim, representative of the victim, being treated as victim in this court. That is as close as they can get. So if they want it, but I would still imagine they would want everything. Let's see what Barron has to say, though.
Is about tainting the jury pool. The one thing that Judge Graf is tasked with controlling. We did a whole opening on that just a few weeks ago about famous cases that made it all the way to the United States Supreme Court, where the court said, no, you have to give that person a new trial. You guys let a media circus take place. You let entirely too much jury pool tainting go on. There's no way the defendant could have gotten a fair trial. That's like his one task here. Find probable cause without tainting the jury pool. That's it. That's his goal. And that's how I would have handled it. And if they'd have said, oh, we're going to appeal your order. Oh, well, I'm giving you what you just claimed you wanted. Why on earth would you appeal that? Fine. You can't see it at all. We're not going to publish it at all then. Go ahead and appeal that. I'll tell you what, I have tremendous respect for Judge Tony Graf after this week. I was very suspect coming into this.
I can say the same. Again, let me know in the chat. I have my microphone stand. I'm trying some new things. I want to have it off to the side like this, but I don't know if you can hear it because it's to my left. So let me know if it should be closer. Just let me know or whatever, if it's fine. But yeah, so Judge Graf, he's definitely shown an interesting side that I'm glad to see. I'm glad to see that Judge Tony Graf seems to really care. He seems to, thank you. We can hear, sounds good. Awesome. Appreciate it. So yeah, this is kind of fancy now. I got my little thing right here, rocking the Rode. I'm scared. Hopefully nothing pops out of this Rode thing and just like shoots at me or something. But hopefully not. I don't think it will, but we'll see. Rode, the reputation got savaged during this. I'll tell you, I don't know if more people want it or not, but it kind of scares me. But it did put Rode in my head. I ended up buying the Rode boom arm, which was one of the more expensive items. Anyways, Judge Tony Graf has done a great job. He's done a great job so far, it seems. Now, I think it's the responsible decision to go and take the time all the way to September 1st, because that's what's going to happen. We're going to need to have Judge Tony Graf go all the way to September 1st but that's going to be when he receives the prosecution, the defense, fully thought out, informative response. Let me see if I can find here. Let me go to Google. I'm going to pull up that one chat that I was in, that AI mode, and I want to see about are required to do. Okay, sorry. So I said, can you show me the official here? I'll share my screen. So it says, which response is better? I mean, you're kind of pushing me in this direction, no? Here, response B is better. The official mandate for the September 1st, I wanted something official that I can show you all, not just me saying it, not just getting it from. Wow. My computer literally just crashed. That was a first. That was very weird. Give me a second. Because my computer just literally turned off and turned back on. I've never seen that before. You guys can hear me okay? Everything's good? My apologies. I'm back. Yeah. Very weird. I'm not even running anything on my computer. I don't know why that would happen, but that's kind of worrisome. Might have to use my other computer. We've got computers for days, don't worry. But let's get back into it. So what I was covering, let me organize my screen again. I'm so sorry, ladies and gentlemen. That was terrible. Thank you for bearing with me on this. Okay, here we go. We are back again. Screen is being shared. Boom and boom. Okay, here we go. You know when you're starting your computer up. Well, we've got a long day today, so you're going to be with me for a while. Enjoy. Okay, here we go. Are we good now? Am I okay? Am I going to survive this? I'm going to survive just fine. Okay, I got to open up. Okay, here we go. Okay, So September 1st, the official mandate for the September 1st, 2026 court date requires that the attorneys are to present live oral arguments and requires Judge Tony Graf to deliver a final ruling on whether the case proceeds to a jury trial. And by the way, for the super chats and stuff like that, I'll read them. I'll read them in probably 30 minutes or so. So this was the final ruling to be decided before the judge, and it will be presented on September 1st. So this is so this says, because Judge Graf stated he would not issue an immediate ruling at the end of the July preliminary hearing, he issued a formal scheduling order detailing the specific mandatory steps both legal teams must complete leading up to that date. So let me make sure my computer is running okay so I don't have to worry about anything. So what we've got is, and I hate to keep interrupting, this is terrible. I didn't plan on this today, so I am so sorry about that. Let's continue. I won't interrupt anymore regarding this stuff, but it was strange. Mandatory schedule for attorneys. So this is their mandatory, this is what their requirement is and how they're going to be approaching this whole scenario. Instead of standard closing arguments at the end of the live witness testimony, which I believe would be today, the judge ordered a rolling sequence of formal written briefings. This seems to be coming from the same person. Maybe we can go over there. Let's see where this is coming from. Okay, so someone is posting continuous as a reporter. Okay, that's pretty cool. I'll go follow that person. All right. Late July of 2026, the prosecution's requirement, the state's prosecutor must compile and submit a comprehensive written brief summarizing how their evidence establishes probable cause. Establishes probable cause. Let's go and see this page here. We'll just keep going. So the prosecution rested today in the Tyler Robinson preliminary hearing. Shout out to Nate Eaton. I don't know who you are, but I guess I'll give it a follow. The defense will call one more witness tomorrow. Then prosecutors will prepare a written brief by the end of July. The defense will have 2 weeks to submit a response, and then prosecutors have 1 week to respond. So prosecutors will have their brief prepared by the end of this month. So they've got probably 15 days or so. Then Judge Tony Graf will rule whether there is enough probable cause to actually send this out to a jury trial. But before that, the prosecutors will have a week to respond to the defense. Because a lot of people might get confused on, well, what are we experiencing? Well, what we're watching is the state, the prosecution, show, hey, this guy's involved in a crime. This is how we're going to prove it. These are the things that we believe are going to allow us to prove that. And the judge is going to say, okay, we'll interrogate that stuff in trial if we go to a jury trial, but we need all of the actual probable cause that could be involved for every single exhibit or piece of evidence shown. So they have to show that, and that's what the prosecution is doing now. And then the defense is going to write back and come back and say, these are all the reasons why this doesn't show probable cause. These are all the reasons why this is what they should do, I believe. I'm not a lawyer, like I've said many times. We could ask Barron sometime, maybe. Maybe I'll ask Barron to come on the show. Maybe. We'll see if he'll answer on that. That'd be nice. But I haven't asked him. We'll see. It'd be a good time. Right now, I have a lot of questions for him. I think this would be a fun little, we'll see if I can. So anyways, when we're looking at how the response from the prosecution, from the defense will be, I would be extremely meticulous and detailed around what exactly every single piece of thing doesn't lead to the client, right? Doesn't lead to Tyler Robinson. That's how I would approach it for me. And I would imagine they would want to do the same. So that's what they're going to do by the end of July. Then mid-August, the defense requirement, The defense team has exactly 2 weeks after the state's filing to submit a formal written response countering the evidence. So the defense team, that's it. At that point, once the judge decides and goes through, once we get into September, they'll have all of this, the 2 weeks of after the state's filing to submit a formal response. That's the response I was just telling you about. And then the prosecution will have 1 week to kind of rebuttal all of the reasoning that the defense is saying this isn't valuable enough to proceed as probable cause, or this doesn't prove anything, doesn't even start to prove anything. If they can get to that point, the prosecution will have their rebuttal. I'm sure they'll have one anyways. Just depends on what the defense is going to be talking about in their responses. And I'm hoping, I don't know what we're going to find out from that. I don't know if we'll see any of that. September 1st, 2026 is when the joint requirement happens. Both sides must appear in court to deliver their final live oral arguments based on those written briefings. The mandatory role of the judge. We can go actually look at Nate Eaton's post. Is that the same one? What do you think? Let me know in the comments as well. What do you think? Here, I'm going to end this poll here, I think. We got 409 votes. Were you watching the hearing yesterday? We have more than 50% said yes on almost 500 votes. So that's fantastic to hear. What do you think? Have prosecutors proved their case that Robinson? Yeah, that's a great question. I'm literally just going to copy and paste that poll as a poll. What do you think? Have prosecutors proved their case that Robinson could have committed this? Is that too many? That's too long. Yeah, there we go. Question mark. Perfect. I love doing polls. Less than 50%. Actually, okay. I think I got a good poll here. The answers. I'll put the poll up on the, how can I do this? Oh yeah, I could put that in the chat maybe. Let's see. Okay, I'll put it like this. So vote in the poll on YouTube. What do you think? Have prosecutors proved their case that Robinson committed the murder of CK? Yes, absolutely. No way. Very little. A lot, but not damning. Let's see. I don't know if I try to do it on the fly. Maybe I'll set a few for the next live stream when we do this. Okay, let's cover what the judge is going to be required of. Evidence review. Judge Graf is required to review all 5 days of testimonies, the redacted audio and video interviews, redacted, forensic ballistics, and the upcoming written briefs. Is the video the judge seeing also redacted or no? I don't think that's redacted, right? No, Judge Tony Graf has reviewed the entire video. Okay. Thankfully, I was like, whoa, wait, what? I don't know anything. I told you, I'm not a lawyer. I don't know shit. Welcome to everybody. We are reviewing, if you're new and you're just joining, we are reviewing what happens from now until the ruling from the judge. Judge Tony Graf has said he wants all from prosecution and from the defense to have them submit, and then he will on September 1st make his decision. And that's what we're covering right now. And we covered the first part of it here, where they're going to have a couple of weeks here over the next few months, couple of months. So it's July, August, September. So you got 2 months. So over the next month and a half, 2 months, they're going to be getting their things in order, and they're going to be having like a second on paper type of hearing, right? That's how I see it. It's a paper on hearing. Or it's a hearing on paper. And then once that is submitted, the judge will have their standard requirement or mandatory role of requirements. The review will happen. Judge Graf is required to review all 5 days of testimonies, redacted audio, video interviews, forensic ballistics, and the upcoming written briefs from Nate Eaton. Probable cause determination on or shortly after September 1st. The judge must officially rule. So on or shortly after September 1st, the judge must officially rule on whether the state has met the necessary burden of proof. Is this the same post? Man, I've gone to the same post over and over. Probable cause determination, binding over for trial. So this is what I said, they'll probably do a bind over. If the judge finds sufficient probable cause, he will officially bind the case over, meaning Tyler Robinson will finally enter a formal plea, guilty or not guilty. Oops. Yeah. Guilty or not guilty, and a trial date will be set. What is this? Full day? Oh, I don't want to see the full day. I was hoping it was like a short coverage of. Is there any news coverage? Let me see. What's on YouTube here? Let's just go to YouTube and see Tyler Robinson case. Hearing. Maybe we can get a quick little couple minutes here from somebody. Oh, the Lance Twiggs stuff. Oh, we got to cover that. I don't have time for that. Let's get to the Lance Twiggs coverage. I wanted to cover Barron on that. Here we go.
A probable cause hearing, we might want to learn the answer to that, but you would be surprised because we did not get an answer to that question. Now, let me go to the text messages and just sort of roll through some of these text messages. Because we have a series of strange, I would say inconsistencies at best, that pop out as we look over these text messages. We already mentioned the fact that he testified he did not see Tyler Robinson, or he did not hear from Tyler Robinson until 11 p.m. And now we're seeing right here, in fact, his phone suggests he did hear from Tyler Robinson at 4:33 p.m. And it's not like this is going to be a surprise. This was available to the state. This was in the state's possession. This was still on Lance Twiggs' phone, supposedly. He could have scrolled back and looked and refreshed his recollection. So we know right there out of the gate, he's already been at least inconsistent or not correct in his testimony. But here's this 11 p.m. Drop what you're doing. Look under my keyboard. Oh, let me go back to, actually, let me do one more thing real quick. Let me go back to the note for just a second. Because we're told Tyler Robinson was a 4.0 student. We're told he was in the top 1% on his ACT score. I looked that up. That's a 35 or a 36 out of 36. That's a near perfect score. To be in the top 1% nationally, that's a near perfect score. To get a near perfect score, you got to know things like math and science, but you also have to know English, and you have to know it pretty well. Basic rules of grammar should come easy to you if you're going to get a 35 or a 36 on the ACT, particularly if you have a 4.0 in high school, then you would think you had taken some sort of consistent with what we learned today. Drop what you're doing. Look under my keyboard. What? You're joking, right? Blank. I tried to delete that. In other words, he set an auto text when he left the house, but at some point during the day, he decided he did not want to send the auto text, and he thought he deleted it, but apparently he didn't. That's what that's trying to convey to the listening public. That's what they want us to believe by showing us this. Oh, gosh. Okay, here's the next one. I'm still okay, my love, but I'm stuck in Orem for a little while longer yet. Did he ever say he was in Orem? Like, if you're reading this, just not knowing what's going on, does he say he's in Orem? He said he had an opportunity to take out Charlie Kirk and took it, but did he ever say, oh, and I'm in Orem? No, he never did. This is the first introduction to the fact that he's in Orem, but he says it as if Lance already knows he's in Orem. Shouldn't be long until I can come home, but I got to grab my rifle still. To be honest, I'd hoped to keep this secret till I died of old age. I'm sorry to involve you. He's talking as if Lance knows he has a rifle. If you read the note, it doesn't say I grabbed my rifle and I went up there to shoot Charlie Kirk. It just says he has an opportunity to take out Charlie Kirk, and I took it. There was no mention of a rifle. And there was no mention in the note that he was going to do it himself. There was no confession that I am the one who took his life. That confession was not in the note. Nor will you find out that the confession is in the text messages. I'll give you an alternative explanation in a second. You weren't the one who did it, right? I am. Sorry. That's the closest you can get to. Did it. But what is it?
Sorry, I was on mute. This is so. If the defense can't beat this, I'm surprised this is even. I've had an issue with these text messages for so long, and the Discord messages, they won't even show us in the court. I don't even know if they're going to get admitted. I don't know what's going to happen with those. But if we're looking at these text messages, what I'm seeing seems to be nothing of identifying exactly what happened to Charlie Kirk. It's not a specific chain. Now, if you want to draw conclusions and say, well, this is what happened, I don't know. This is as close as you're going to get. I don't know. This is not an admission of guilt for me.
I don't like pronouns. They're not specific. They're subject to confusion. Did what? Did it? You're not the one. I'll give you some different. You're not the one who was involved in a plan with other people, were you? I am. You're not the one who drove the getaway car, are you? I am. You're not the one who supplied the rifle that took his life, are you? I am. I mean, it could have been anything. It could be anything here. They're talking about taking a man's life. You better be doggone certain you know what it means.
100%.
I thought they caught the person. No, they grabbed some crazy old dude that interrogated someone in similar clothing. I had planned to grab my rifle from my drop point shortly after, but most of that side of town got locked down. It's quiet, almost enough to get out, but there's one vehicle lingering. I want to go back to the timeline here. This conversation started at 11.
He points something out here I didn't think about.
Where do we know about where Tyler Robinson was at 11?
And this is a very good, this is very, very astute.
Well, the Penguin Steakhouse said he was there at 9:30, which means at 11, he'd have been an hour and a half.
Yep, we're going to be joining the live hearing. I'm going to open up a window to make sure that we're on it. With that, I think KSL is the one. Let me pull that up real quick. I'll show you. So KSL live. Is there a live stream? You can go live. Yeah, we're going live today. So we are going to be watching it in full. Hopefully it's just a half day, but I'm going to stick it out with all of you today. This is East Idaho News, whose AP's been covering. Okay. I don't mind seeing what's going on here as well. We can watch. But they are. So they are walking people in right now. Oh, look, it's Kelly Raybon. That's the homie, Kelly. What's up, girl? What's up, Kelly? We see you, girl. I was just texting her. Yo, we are watching you on the live stream.
And then you had the guy who was back there. He was the one that spoke on the grab.
Wow, that's so wild. Let's see if she sees my text right now. She's going to hit us back. I'm going to send her a link. Let me see if I can get her to come in. Let me see. She's on the ground. We got to get her to come in. Come on, you're on the ground, and we are looking at you. Is she live? She must be live somewhere. Let me see. YouTube. She probably is, and that's probably what it is. Kelly Raybon. Let's take a look. Yeah, she's live. Okay. She's live. I wish you could join lives on.
I don't know which one is the AP camera.
Yes,
Oh,
she's live.
actually, I see
Let's
it
see.
now.
We are watching.
It's directly across from me.
Yo, we are watching. Why does that keep echoing back? Is he playing me? Is he watching me watch her or something? Okay.
Yeah,
I
if
don't
anyone
mind
is in
seeing
his
what's
chat,
going
make
on
sure to
here
let
as
him
well.
know that.
Why do I hear myself? That is strange. He must be watching me. Okay, cool. So that's what's happening right now. I'm going to keep my eye on this. I'll keep it on mute in the background, and I'll keep it on my other screen next to the chat, and we'll keep an eye on that. Wave Kelly. Can we get Kelly to wave to us? Wouldn't that be cool? Let's see if hold on. Let me see. Where is she? Anyways, okay. I'll chill out. I was having fun with that. It was cool. I didn't expect that. All right, so back to what I was doing. Let me read some of these super chats. Actually, let's do that. What's up, Critter? Good morning, Danks. Before I read the super chats, I want to cover more of. I'm just going to read these top 3 first, real quick. These first 3, and then I'm going to do more of the Lance Twiggs stuff with Baron because I think it's important. What's up, Critter? Good morning, Danks. Thanks for the 5. Good to see you. Thanks again for covering the before show too. Love all y'all, Kristen. Thank you. Yeah, it's a pleasure to be here. I'm gonna stick it out through as well. My dogs don't bother me too much. They're never a bother though. Julie, $9.99. Hey, Danks, stopping in to show some love for all the live streaming commentary and updates. Christ is King, much love, brother, in Christ. Christ is King indeed. Thank you. God bless, Julie. I appreciate you. Good to see you. Julie again with the $9.99. Thank you so much. Off topic. FYI, Waze app updated terms. If you have any concerns or disputes with the app, you have to reach out to their corporation in IL. Interesting. I deleted it. I use navigation because I drive to see patients. Yeah, very interesting. Very interesting. WhatsApp also is one of those. All right, let's go back to Baron and let's see what he says about not just the text message. Let's move to where he covers actually Lance Twiggs. It might be before here. Let me see. Where is Lance Twiggs? Is it here? Or is it after? Maybe it was after. Where was it? How did I miss it? Was it earlier on? I thought he covered he had a whole oh, is that 44 minutes, right? No. All right, hold on a second. Am I tripping? Lance Twiggs video test.
Getting to today's hearing.
Okay. Here it is.
We had Lance Twiggs, but not in court, because that would be transparent. That would have given the defense an opportunity to cross-examine him. So
She said hi. Tell her I said hi. Hope she's doing well. Tell Jordan I said hi as well. What's up, Kiki? Come here. What is it? She wants attention. Here. She wants some attention. Okay. You want love. You want love. Yes, I'm here. Okay. You've got a little attention. Now my other dog's coming up. Oh, here we go. Okay.
Claim to want to be transparent. We don't really want to be transparent. The state doesn't, surely. Instead, we want to carefully curate what you're allowed to see. But we got Lance Twiggs. Let me close these two. And he says right here, he did not get a text from Tyler Robinson all day until, now this may not be the loudest video I've ever played. It's as loud as I can make it. I can turn it up on this end a little bit, but I think that only goes to my ears. And I don't know if there's closed captioning yet. Oh yeah, there are. Here we go. So let me share this with you. We got Lance Twiggs talking about his communications with Charlie that day.
Get up on September 10th. Probably like 12 to 1 p.m. You didn't have to work.
So Lance Twiggs conveniently slept through the.
It is very strange, this Lance Twiggs interview. Very strange. I don't understand it. I don't understand it. The guy he's like, I'm worried. I'm kind of concerned. I'm concerned about Lance Twiggs.
1 p.m.
I say I'm concerned because they got 2 confessions. They used the second one. We don't know who's in the room. There's 2 people with just an avatar, no video footage. Who are these people? Where are they? Where is he? Why does he look so pale and scared and
You didn't have to work that.
So Lance
Draw
Twiggs,
your own conclusion, but he doesn't look good. Let me know if this video camera style is suitable. I'm trying different things because having him on that side of the screen, I don't want to be next to him there, but
conveniently slept through the event. Conveniently slept through the event. Tyler Robinson got up at 4 a.m., allegedly left the house. Lance Twiggs was just snoozing. Just snoozing. 12 or 1 p.m.
day. No. And
Yeah, he didn't have to work that day. That's awfully
did
convenient.
you hear from Tyler? Did he call or text you before then? No, he sent that message in the group chat I mentioned, but he didn't message me directly at all that day. Okay. When did you first hear from him on September 10th? It was at 11 o'clock with that like automated message.
So that's his testimony under oath, under penalty of perjury. He was advised, and I can go back and play it for you. He was advised that he had to be honest, that his deal depended on him being honest. Well, that's weird. That's weird. Because, actually, where are the texts? Daisy. There's the 11 p.m. auto text. Drop what you're doing, look under my keyboard. What's that right above it?
what can I don't understand what an auto text is. I mean, I know what it is, but what is the auto text referenced in the court with Lance Twiggs and the text messages? The auto text reference in court refers to a scheduled text message that Tyler Robinson set to send automatically on the morning of the shooting. This auto text was meant to alert his roommate and romantic partner, Lance Twiggs, whom Robinson addresses as Luna, to find a hidden written confession note back at their apartment. The hidden note and auto text connection. During day 4 of the preliminary hearing, Utah State Bureau of Investigation agent Brian Davis read the text messages and the contents for the note aloud, which was hilarious, was kind of ridiculous, but only because we've seen it so many times. The text message was sent automatically. How was the text sent auto? Precise carrier. Tyler Robinson has not been publicly specified by the court. Testimony confirms the message was sent as a scheduled message delivered exactly at 11 a.m. on September 10th. So it was a schedule. So is that a thing? I guess that's a thing on iPhone. I've never seen that. I'd never ever. I mean, why would you send an auto text from your cell phone? That doesn't even make sense. What, in case he died or something? What, is he going to have a bot have a conversation with him that stored his memory? I could do that. Was he up on that level? Writing bots to have conversations with people after he dies? I don't know, man. So what's the point of sending that message? I guess it does deliver the point. Look under your keyboard. But why send an auto message and then manually respond back? How long was the difference? Let's go back to the text. So Monday, Wednesday, 11:44 p.m. Wait a minute. What's that? Dog trying to get out. Think about this. 11 p.m. That's what Barron was talking about. That's what he's talking about. Okay. So yeah, the text was sent. Is one of my dogs outside? Oh, my wife left the dogs outside. I'll bring him in a second. That's interesting. So at 11 p.m., that is when. Oh, wow. That just kind of clicked for me. That really clicked for me. And also my dog is like scrapping at the door. Hold on a second. I'll go get it. I'm going to play this, but this is.
You see that right there? Wednesday, 4:33 p.m., Wednesday, 11 p.m. So his testimony under oath was, I did not hear from Tyler at all until 11 p.m. That's his testimony.
Hold on, let's go.
Drop what you're doing. Look under my keyboard.
Let's go.
But that's not true because he heard from him at 4:33 p.m. I love you, mwah, mwah. I love you, Morsies, mwah, mwah, mwah. Notice the drop what you're doing, look under my keyboard, and the I love you, mwah, mwah are from the same person. They're from Tyler Robinson. If you don't believe me, it says it right here, according to the screenshot, if this is at all accurate. So we have him just bald-faced lying under oath. And don't tell me he didn't remember. Guys, this is an 1102. This is prepared testimony. This is in a controlled environment. You don't think those text messages were in that room? You don't think the text messages were in that room? That Tyler Robinson sends a text message at 4:33 p.m. and Lance Twiggs even responds to it?
It's more than that, though. It's the actual conversation, too. But yeah, what's interesting about the text messages is that happened at 11 p.m. I had, for some reason, in my mind that they were having this conversation while the people were searching for him on the crime scene, no? Can I get a poll on that? Let me end this poll. Let me see. So, start a poll. Didn't Lance and Tyler, here, I'll just do a LT and TR, talk via Discord message before 11 p.m.? I don't even need to put a poll. I see you guys are saying that could be so. Aren't yeah, that's the thing, is like they aren't that's the thing. See, that's why now I see. I need to write this as a note. Now I see why they didn't want to show the Discord messages, because the Discord messages directly contradict the text messages, because the Discord messages were earlier. And that's where his confession to the group lies, is there. Not lying lies, but lays there. It sits there. Correct? I'm understanding this properly, right? So if Lance Twiggs or whoever Luna was, if the Discord messages, let's go find them. Tyler Robinson Discord messages. Let's see what we can find here. Images. Does it have the time of the Discord messages, or did they just completely scrub them? I have them somewhere, but I don't want to go looking. Discord. Who was the person that showed the Discord messages? Maybe I could just type their username in. Is it this one? 9/12. What? 9/12 at 1:58 p.m. Instagram. Okay, so this, and then they're saying this is on the 12th now? I don't understand. Can I do this? Oh, my computer is freaking out. That's not good. Tyler Robinson Discord messages. We're on Instagram now. We're traveling the whole internet. Don't worry, I'm watching for the case right now. You can see they're not doing anything just yet. I've got my eye on it. So the Discord messages. Okay, is this it? September 11th, 8:57 p.m. So this is 8:57. I don't know what time zone. I guess this is coming from Utah police records indicate Tyler Robinson was already in custody when the so-called Discord confession messages were sent. 9/11/2025, 8:57 p.m. I have bad news for you all. It was me at UVU. None of this is adding up, you guys. This zealous monkey who they're saying is him doesn't add up, because that's 8:57 p.m. He's already, I have bad news for you all. It was me at UVU yesterday. I'm sorry for all of this. I'm surrendering through a sheriff friend in a few moments. Thanks for all the good times and laughs. You've all been so amazing. Thank you all for your everything. But then, so that's at 8:57 p.m. in that same day, which I guess I'll just bust out a calculator to make, or a calendar to make sure. We'll go to September. That's 2026. We got to go all the way back. September 10th, and the 11th is Thursday. Thursday evening. So this is Wednesday. Okay, am I confused then? I guess maybe I thought, here, let me see. What does this say? 9/11, 8:57 p.m. So they're saying this text message is a day later because Wednesday was the 10th, was the day he got shot. Here, well, let's see if I can just open up calendar. Because this is what it takes, kind of some important investigating. Let's see. Where am I going here? Do I not know how to work a damn calendar? Okay, here we go. September. Show the whole year. Let me share this tab. Go back to 2025. We'll zoom in and we'll go to September 10th, 2025. Okay. So that's September 10th, 2025, right here. And then it's a Wednesday. So Wednesday, September 10th of last year, the day Charlie was killed, this right here was the same day. The Discord messages was the next day at night. And I don't have all the other messages, but I just want to let you kind of tie the timeline together what they're saying. Maybe I'm wrong and that the timeline doesn't add up, but it definitely doesn't add up when it comes to the police, the arrest, the time that he was in jail or arraigned or whatever, not arraigned, but Mirandized. Okay. So we've got that. I'm just trying to figure everything out. You know, it's this Lance Twiggs character is giving me a run for my money.
I left it for.
So again, those messages covered from September 10th to the evening of September 11th. Now, September 11th, what time did you see Highliver on September 11th?
Yes.
When did you first see him on September 11th? So this is the day after the shooting.
Yeah, I saw him when I woke up. Like I said, he was up and around doing a lot of stuff around the house.
Saw him when he woke up the next day. Well, we've looked at these text messages a lot. I don't have to pull them all up and.
There's a lot more. I want to get through some of this.
Okay, before he came home, had you seen the press releases, any of the media on this?
I'd seen one Instagram link a friend of mine had sent in our group chat, but I hadn't really looked into it at all.
And had you seen the images that were released of the suspect?
I did the next day. I don't.
Let me see. I have been not reading the chat.
think I saw any on the 10th.
Okay. I'm going to stop here for a second.
Yo, what's up, Ian? I didn't see you in the chat. The idea is that if he died, this is from Mr. Ian Carroll. Good to see you, man. Let me pull this up over here. I don't know where that was at in my, but I'll read it. The idea is that if he died, the auto text would tell Lance what happened. That's the narrative, at least. Yeah, that's where I drew to conclude. That's what I kind of figured. Let me see if I can pull it up on this side here. Here it is. Barron also points out that there's no timestamps throughout the text, indicating there was no significant time gaps between messages throughout the whole message chain. Barron also points out, yeah, that's very interesting. There's no timestamps throughout the text, indicating there's no significant timestamps between messages throughout the whole message chain. Yeah, we can go to, I have all the pictures here. I think I have a few at least. Let me see. Where are they? So I have a bunch here and they're under this main post. I guess when I look at, so yeah, all through here, there's none. But see, that's why I'm wondering, like, why do they say this is an iPhone? Because on Android, I can click it. Here, let me see if I can close it and show you like one text here or something random. For example, oh, this isn't a good one. Let me see. I'll show you guys what I'm trying to say. Maybe I can. One second. Trying to show. I don't want to show any text messages. That's why it's kind of like, never mind. When you click on it, basically what I'm trying to say is when you click on the message, it will show the time. So that's how it shows on Android. I don't know about iPhone or Apple, but like when I click the text message, which I keep getting a bunch of, I'll mute my text. It doesn't show. It shows only when I click it. But if this is all day, you would think like after a certain amount of time, I don't know the analysis of like when does the time start to show again, if there's a certain amount of length between the amount of time that went through the post. Let me see. Let me make sure I'm not missing anything in my chat. Okay, there's a bunch of people now messaging me and stuff. Everyone, I'm trying to run a show. Please. Thank you, Ian. Let's see if he said there's a bunch of messages here. So, yep, that's why Barron is so on top of when Tyler was read his rights, because the Discord messages don't work with it. That's right. Yeah. Man, it is so wild to see all of this slop and how they expect us to just see it. Even like this is even the probable cause, you can barely say for me passes. But and in the court of law, I don't know. The barrier is so low. Yeah, no, 2 different days. Yeah, I got there. I ended up getting there. So when we're looking at all this Fed slop, I don't understand how the barrier to get somebody on trial for their life can be this messy. It needs to be cleaner. You know what I mean? I personally believe it needs to be cleaner. I feel bad, I feel bad that this could happen to anybody. I feel like this is a scenario that could happen. I've said it so many times, could happen to any one of us. And it's worrisome. It is quite worrisome. I'll pull up this while we go through some of the super chats. Thanks, Ian, for stopping by. You're always welcome to come on the show. Anytime. You can always say, drop a link, and I will anytime, bro. You're more than welcome. I'm going to be here for the day. I think we're going to be doing a half day is what they said. So we're going to be kicking back and enjoying that. I'll read the rest of some of these chats. Unless they're going to be going later. I think it says since 11 a.m. Eastern, which is 11 a.m. Eastern is 8 a.m. my time. And we will be watching that. Hopefully we end up getting, well, I want it to be whatever it is. I don't say hopefully and like I hope that it's short. I just hope that it is short only because I don't want to be here for 10 hours again. But yeah, no, either way, I want the truth, right? I want the truth from everything. I want the truth of what actually happened. I don't want garbage in, garbage out, because this garbage in has been getting filtered out and we're tired of it. We're tired of the garbage. The garbage. Philippe, what's up, man? I saw you hold me down yesterday in the live stream with the homies. I appreciate you. What's up, bro? SEK50. Hey, bro, great work on X. They could just change the name of a contact. Fed Slopper, Gary, or that copper and send messages. Of course, that's a major problem with this. They could literally send a message from any number and have it maybe besides 911 and like a 1-digit number. If you have even then you could save an email as a contact in a cell phone, and you could be emailing back and forth with the contact. I'm pretty sure. So maybe not, but you can definitely save the contact. But either way, you can definitely have anybody's name. I could literally put every single person in my phone. I could just name them someone famous. You know what I mean? And just be like, yeah, I got all these famous people in my phone. You know what I mean? Wouldn't that be wild? Yeah, we're doing the case today. I saw some people asking, so I'm going to be doing the case today. Let me see. Where are the chats coming from? Yeah, we're doing the case today. So we're going to read some of these super chats. I tried to cover as much as I could. I mean, I don't want to keep going. There's a lot about the hearing. There is one thing. Maybe I could cover this. I think that Barron points out here. Let me go back, actually. Sorry, hold on.
He's not accused of throwing a screwdriver 142 yards and hitting Charlie Kirk in the head or the neck. So I don't care about a screwdriver. He's not accused of strangling.
Let me see.
Up the case.
Where I was very intrigued by what Barron had pointed out was who was possibly in that room.
House. I'm on my way back. You know, he stopped and got gas in Cedar City at like 7. And so we were trying to make a timeline in our head. But now he's saying he saw him when he woke up the next morning. Again, this would have been nice for cross-examination. This would have been a nice opportunity to, even if you're just clarifying, hey, we're trying to put a timeline together. Our client is on trial for his life. Can you clarify why the text messages seem to indicate you were at your mom's house celebrating your birthday, and now you're telling us you saw him when you woke up the morning after? Being the fact, if personal,
Fast forward a little bit.
What you know about him.
I think we saw this.
He didn't even notice it happened.
What he pointed out, I wanted to just show it, but I don't know where he has that at. But essentially, he's saying, like, dude, you don't know, like, you might have gotten lost. Tyler Robinson is up here. You should have had him speaking. You know what I mean? You should have had him live in court. And so he points that out. You don't know who these other two people are. He points that out. He wasn't able to identify, but then he ended up identifying it's like some part of some of these images. So it's very I want to find that part.
And then jeans. So
yeah, here we go.
Wearing a hat is, but I wouldn't say it with a.
So they
back
ask
up a little bit, and we'll do this again without my interruption.
Do you recognize the person in these images?
I wouldn't say it with 100% certainty just because of camera quality, but that looks like him in terms of the shoes he's wearing, the sunglasses. I don't think I'd specifically seen him wearing that hat, but he was usually wearing a hat, and then jeans. So,
Well, he's got sunglasses on and a hat. I've never seen him wear that hat, but he does have a hat on, and he usually wore a hat, you know, and hey, he had an affinity for jeans. And he owns a pair of Converse Chucks. So yeah, you know, it kind of looks like him. But I can't say for sure. What? I mean, imagine this case without Don Jr. sitting in the front row. Imagine this case without Jeffrey Neiman getting up there and whining every 10 minutes on behalf of Erica Kirk. Imagine this case without Erica.
And again, Barron points out, which I didn't know, Neiman was the person who got Acosta in. Let me see. What time is this? 1:08:20. Let me go back to where he explains this. This is interesting.
It would reveal their true motives. Not good enough. I question your motives because you're claiming that the only reason you want it public. I don't think it.
Listen to this here. I don't want to keep like jumping forward and stuff. That's annoying. Let me get to that right here.
Believe it or not, again, the victim's representative has filed a pleading in the case. Let me say something about Jeffrey Neiman real quick. You know who Jeffrey Neiman represented? You remember the U.S. Attorney Acosta, who cut the deal with Jeffrey Epstein so that Jeffrey Epstein would not have to serve a terrible prison sentence for his crimes against young people?
How many times do we have to see that this lady is super connected to the whole child stuff. It's like indirectly, but kind of weird that this person is involved. It's like, what?
And that was back in 2008. And he got this sweetheart deal where he got, like a year and a half in jail, but he was able to go home. He just had to basically do time on the weekends. And he basically had an office in the jail. He could kind of come and go as he wanted. That was a guy named Acosta. He was the U.S. attorney who cut that deal. Well, fast forward, and Donald Trump wants to appoint former U.S. attorney Acosta to a cabinet level position. So it has to go to the Senate for confirmation.
So that's kind of...
During the confirmation hearing, somebody said, hey, wait a minute. The hell's this deal about you cut with a child offender? What's this all about? You know who he hired to represent him in that? Jeffrey Neiman. So once again, we have Erica Kirk 1 degree away from this situation. It's too close for comfort. It's just weird. Like, there's like 4 million lawyers in the country. Pick a different one.
I agree.
Pick a different one.
I agree. Let's go back to 108.
Bro, imagine this case without Jeffrey Neiman getting up there and whining every 10 minutes on behalf of Erica Kirk. Imagine this case without Erica Kirk crying and shaking in the pews, as Billy Webb reported. Imagine this case without the national media attention. Imagine this is just some guy named Chuck Smith, and he was killed in a dark alley. And you've got these 6 images of the guy who supposedly did it. And you go home to the boyfriend and you say, do you recognize this guy? And he's like, I don't know. I mean, he likes jeans. I've never seen him in that hat, but he likes hats. He wears a lot of hats. Now, I've never seen that hat, but he does wear hats. And he wears sunglasses. He's a sunglass guy. Yeah, I mean, Chuck Taylor. You know who else wears Chuck Taylors and jeans and sunglasses and hats? Like everyone else on the planet. Every other 22-year-old kid in Utah. Almost everybody.
So when he responds, let's get to the actual questioning and answering from Lance right here.
So, and sunglasses, and he owns jeans and he owns shoes.
It definitely, especially the bottom, the last 2, definitely do look like him.
Look like him. That's as close as they can get. Nobody can say for sure. This is definitely Tyler Robinson. That's definitely, of course, that's Tyler Robinson. It definitely is him. Nobody has been able to say that. Nobody. Not one person has said, yes, I know for certain because of this. Now, police officer and some other witnesses or people that have been brought up on the stand have said that's Tyler Robinson, but that's not what the picture shows. You can't tell that for sure. You can't tell that for sure. Okay.
This is why he should have testified in court. Where do you see Lance Twiggs on this screen right here? You see him up there in the little bitty corner up there? You might have lost him. He's this top right square on this Zoom call up here. And you can see down here, there's 2 other people on this call who are not visible.
I found it interesting. Yeah, this is what I wanted to show you.
And you have no idea who else is in that room or where they're positioned. You have no idea what they're doing. You don't know that there's not somebody standing off camera going, yes, that's him. That's him.
100%.
Because in a courtroom, that crap wouldn't fly. He'd have been stuck with I don't know. He wears jeans. He's got shoes on. I've seen him in a lot of hats. Not that hat, but I've seen him in a lot of hats. So, yeah, I guess so. I'm not 100%.
So that's it. That's his cover. I'm going to bring this over here. We are going to have this on stage. I'm going to read some of the chats here, and we're going to jump right into the show, to the event, to the big event of the whole year so far, the Lance Twiggs final day 5 finale in court. Not Lance Twiggs. Did I say Lance Twiggs? I might as well. Tyler Robinson. The Tyler Robinson trial and to be honest with you, I think Lance Twiggs has a lot to do with this case, right? I really do. What's up, Mom Ranger? Member for 5 months. Quit vaping immediately. It's bad for the health. Trust me, I hear you. Thanks for the super chat. Mr. Lamrocker 499. They're showing all of their evidence now because they want the general public to accept his guilt. They have no intention of Tyler making it to trial. Yeah, that's interesting concept for sure. Interesting, yeah. I have a theory that Lance Twiggs won't make it to trial. If Lance Twiggs doesn't make it to trial, they could still use the evidence that they got from Lance Twiggs to get them into trial. They can use that. I don't know if they will. If something happens to Lance Twiggs and he disappears, it's not going to look good. Thanks for the super chat. September 1st, that's correct. That's correct. Super chat. Thank you. September 1st. Thank you. Colleen Kelly, $5. Thanks to all you handsome guys for covering this. Thank you. Just so you all know, we are going to be watching the trial preliminary hearing today, not trial, day 5. They said it's going to be about a half a day, so we'll see what happens. I'll do most I can. My daughter is off today, and so I might have to get up and do stuff, but I will be watching this, playing it, streaming it, and also I might pause here and there to give commentary. Try my best not to. You let me know if you decide, oh, you've stopped too much or not. I might want to say things. I might not. We'll see. Playing it by ear. Thank you, though. Thank you so much for the compliment. Jolly Lollipop, $2 newsflash. Hawaii just outlawed nicotine vapes. What? I better get a puff in. When I was in Singapore, when I was doing crypto, I was holding an event in Singapore with a friend, Kelly Kellum, from, I'll show you their channel. So a good friend of mine is one of the owners of this crypto YouTube channel right here, Discover Crypto, and he also has his own channel separate. So it's like a whole group of them. This was BitBoy Crypto. If you know anything about BitBoy Crypto, this was his channel. They sued for the channel. He was the face of it. You might have heard of it. Well, my friend Kelly Kellum, he is one of the people that is part owner of this channel, and he does content. So he's a DJ as well. We did a show together. He's a DJ as well, but his channel is oh shit, I can't remember now. It's anyways, we were in Singapore, he was DJing, and we held an event. And what's funny is I didn't know vapes were illegal. Like I flew, I brought my vape juice, everything like that. And then the last day I was there for like 6 days. On the last party night where all the crypto heads, all pool club, nightclub with a pool, and it was beautiful. And but I was co-hosting the event. So like I was one of the VIP people there, getting there early, showing up, like whatever. And the security guard wouldn't let me in with my vape. He's like, "Oh, I could arrest you." And he didn't speak much English. And he's like, "You have to give me your vape." And so he made me give him the vape, and I couldn't get it back. And he wouldn't let me he just threw it in the trash right next to him, and I couldn't get it. He was like willing to take me to jail over it. It was crazy. Lance Twiggs' phone under F, I tried to delete. It looks like they are 2 text clouds. Don PCB 499. Let me open up. Let's see here. You said LT phone under F, I tried to delete. It looks like there are 2 text clouds. What do you mean? I tried to delete that. Oh, like there's more text under here? Is that what you're saying? I'm trying to read the chat, but I don't know if I can see it. But anyways, definitely looks like there's definitely more text for sure. Thanks for the super chat. Let me get back to the show, the event. What's Kelly up to? Let's see.
It just is kind of
Kelly's probably getting coffee.
So that's
I already got my coffee, but I
Jordan. Okay. All right. Shout out to them. Much respect says put that on stacks for the 20 baller. Much respect. What if Candace is in on the act? Why wouldn't she be? Charlie, of course, would know to include her. The whole CO, Candace Owens versus TPUSA, is an act. They all have plenty of money and go on living life away from real threats. Definitely have thought about that in the past, but, and I mean, if that's the case, she's crushing it. I don't think it is, but I definitely I can see, if you're trying to sell a story, she's doing a damn good job of, trying to figure out what happened to Charlie Kirk, which is what you would expect out of a really good friend. It is very interesting that she has taken on this task and she's not going to stop. She's said it herself. She's not going to stop. Thanks for the 20. Philippe, they have better security than Charlie Kirk. Oof, that's tough. Let me see if the Associated Press has outside footage as to where this is just showing us the little screen there. Where's AP? Here it is. We can kind of look at both sides. Oh no. Oh no. Here we go. Should go to it. Here we go. AP. You can see outside in here. Oh, it's looking up now. 4th Judicial. Yeah, there's a lot of security there. Put that on Stacks for a 25er. Thank you. That's why everything is so obviously off. No intelligent person would act like Turning Point USA. It's all over the top to make this PSYOP a soap opera. And Robinson probably was intercepted before attempting real assassination. Thanks, dog. Yeah. They're definitely acting sus, bro. And like when you think about and you add Blake Neff, and you add Andrew Colbert, when you add like Erica Kirk acting all freaking weird, what is that, dude? What is that? You're willing to speak on some things, but not others. It's terrible. It's terrible. Thank you, Stacks. Jen Common, good to see you. What's up, girl? $9.99. You have to have a certain iOS to send a scheduled auto text message. Thank you. I know because I still have an iOS 17, and therefore I cannot schedule text messages. I actually wish I had this feature. Oh, okay. So what model? Let me open up Claude. Let's see. What model iPhone, iOS do you need to send auto text messages? All right, I'm going to find out. Thank you, Jen. Susie Lynn, Suz Lynn, appreciate you. Thank you. Did you mean to send a message on the first one? Thank you. Hi, iMessages show the word Wednesday twice. I noticed that. It says Wednesday 4:33 p.m. and then it says Wednesday 11 p.m. I did notice that. It says 11 p.m., right? On the dot. Oh, Kevin is calling me. I'm live. Yeah, interesting. Thank you, Suslin. Sisters Onda, $5. Sister Shonda, $5. At Dankster, when the FBI came and retrieved the rifle 6 hours later, right? That same night. So by 11 to midnight, the rifle was already found, right? 6 hours. Was it 6 hours or 4 hours later? Was it 6 hours or 4 hours later? I thought it was 4. Here, let me go back to my AI mode. Let me see here. Okay, and then how many hours until after the, here, I'll just screenshot this. answer this. Let's see what it says. Yes, according to evidence presented, the preliminary hearing, the timeline aligns with law enforcement locating the rifle on the night of the shooting. During cross-examinations, testimony from the Utah State Bureau of Investigation confirmed that a massive sweep of the area surrounding the Utah University campus commenced immediately following the midday assassination. Let me make sure we're not live. Oh, we're live. Let's get it.
Please state your roles for today's hearing.
My role is to capture pool photography, still photos. My role is for video in accordance with the court decorum order.
And I apologize. Would you mind putting your names on the record?
Tess Crowley, Megan Thackeray with KSL.
Thank you. Have you both reviewed the court standing decorum order?
Yes. Yes.
Do you understand the requirements set forth in that order as it applies to your activities today?
Yes.
Do you require additional time to review the order or to adjust equipment to ensure compliance?
No.
Do you anticipate any difficulty complying with the order?
No.
All right. Thank you both. Before we begin this morning, the court wishes to acknowledge the importance of the safety, dignity, and well-being of all those who are present or who may be present during these proceedings, including the parties, counsel, witnesses, court staff, and members of the public. The court is also mindful of its solemn obligation to protect and uphold the constitutional rights of Mr. Robinson and Ms. Kirk. In furtherance of those important interests, all persons attending these proceedings are reminded that portable electronic devices are not permitted in the courtroom or on the fourth floor. Cell phones are not permitted in the courtroom unless expressly authorized. Any unauthorized possession or use of a cell phone or electronic device in the courtroom may be addressed by the court. For those individuals who have a cell phone, I invite you to join me as I silence my cell phone to ensure that the proceedings today can proceed without distraction. The court also expects every person in attendance will be treated with the dignity and respect to which they are entitled. Consistent with this court's standing decorum order, all spectators shall remain quiet, civil, and orderly at all times. Spectators shall not engage in conduct that is distracting, disruptive, provocative, disrespectful, uncivil, or threatening in any manner. Spectators shall not make audible comments of any kind, shall not shake or nod their heads, and shall not make gestures or of other visible reactions during the hearing. Spectators shall also not wear or display pins, buttons, signs, clothing, photographs, or other items expressing support for or in opposition to any person connected with this case or expressing any position concerning the status of this case as a capital offense. The court appreciates the cooperation of all present in maintaining a courtroom environment that is safe, respectful, and orderly, and faithful to the rights and dignity of every person involved. All right. My understanding is the parties wish to address an issue before we get started. Is that correct?
We may.
Mr. Novak.
Thank you, Your Honor, and good morning. I passed up to the court after providing copies of it to counsel for the state and counsel for the media, a single piece of paper. Does the court have that?
I do. Thank you, Mr. Novak.
Thank you, Your Honor. So every morning, this court has a colloquy with the camera operators about their ability to comply with this court's orders. And they acknowledge that they understand the order and that they can comply with it. And the court asks them if they have any problem with it. And they state to the court that they do not have a problem with it. We also spent many, many, many hours of court time addressing which exhibits will and will not be published through the electronic media. And this exhibit, the court ordered would not be published through the electronic media, and it was. And without belaboring the point, the court can imagine our concern that the media and the state who control this exhibit and the publication of this exhibit in the courtroom as per the court's orders failed to comply with this court's orders after all of the effort that we made and the court made to make sure that the court balanced everybody's rights, including the rights that we're concerned about, which are Mr. Robinson's. No doubt the counsel for the media and counsel for the state will say that it was a very, very brief mistake, that it was corrected as soon as they realized the error, but it's done. It's out there, it's photographed. I'm informed secondhand that if I want to buy this image and maybe even have it framed and put behind museum quality glass, I can do so and put it up in my office. Obviously, I'm not going to do that. But my point is, it doesn't matter how long the court's order was violated. When we live in an electronic world, it's done and it's permanent. And we just wanted the record to be clear that we're concerned that the court's orders have been violated, and they've been violated with respect to an order that was specifically designed to protect Mr. Robinson's right to a fair trial. And I don't want to belabor the point any further. I'm also not going to refer to the exhibit with any more specificity because it's not necessary.
Is there a requested remedy or potential sanction that you feel is warranted given the actions which you have outlined this morning?
I think that we would like to think, when I say we, I mean Mr. Robinson's counsel, about that. We have, as the court knows, repeatedly asked this court, moved this court, not to have electronic broadcast of this proceeding, of any of the proceedings, and specifically this proceeding. The court denied those motions and overruled our objections to the specific EMC requests. So I think it's a little premature, but I can represent to the court that we will suggest a remedy in advance of the next hearing.
Well, Mr. Novak, I appreciate that, but I would ask that if it is something that is concerning, that it be addressed immediately. So I'm not going to wait until this. I recognize and appreciate what you have described, and this was on my mind a lot last night as well.
Okay.
I don't want to sit on this. So I ask you respectfully to confer with your counsel and come up with that, because I want to address it. I agree with your counsel and come up with that because I want to address it. I agree. It is concerning and it warrants examination and to be addressed immediately, especially as we have a little bit left of our preliminary hearing. So I want to give it the weight it is needed, and I don't disagree with you.
Then why don't we beg the court's indulgence? We don't need to empty the courtroom. We can go talk about what we think an appropriate measured sanction would be, and we can bring that suggestion back to the court in a few minutes.
All right. Well, before we do that, I want to turn to the state and to the media to address what you've addressed. And then obviously if there's a part two, then therefore.
And I appreciate the invitation, and I also appreciate the court's desire to address the consequences, if any, immediately.
Thank you, Mr.
I was
Novak.
not trying to delay it. I just think it's an issue which warrants some thought. The court has said it gave it some thought. We will have a suggestion very briefly.
Thank you. Turning to the state.
Thank you, Your Honor. I think at the outset, it's important to recognize that everyone's doing their best here. The court is, I know the clerks are, I think the media is, we certainly are, and the defense is. This issue came up in the context of an examination of a witness. One exhibit was published before the exhibit at issue was also brought onto the screen. I explained what we were going to do, and then the exhibit was brought onto the screen. I reviewed the video last night. The camera captured this for approximately 2 seconds. The camera operator, I think, acting in diligence and appropriateness, immediately panned as soon as she realized that there was a new exhibit on the screen. The court took it down. And as soon as they realized that an exhibit was on the screen, I immediately instructed my paralegal to take it down, and it was. Defense, I think everyone involved here made quick and appropriate efforts as soon as they realized a mistake had been made to remedy and mitigate that issue. As I explained what I was what we were going to do, defense counsel did not object as that happened. And the reason I bring that up is because the requirement for timely objections.
I'm going to pause it real quick. I think what they're talking about, because they dropped 2 on mistake. I think this was one. This image right here was one they weren't supposed to show because they pulled it off air as soon as they realized it, which is the burned paper.
It is also in an earlier pleading, which is the information.
Sorry, it's this one.
Moreover, I do want to say this exhibit was read into the record. It was allowed to be read into the record earlier. It is also in an earlier pleading, which is the information. This portion of that exhibit, I understand, is in the information. And it is largely cumulative of Exhibit 16 and 16.1, which were previously admitted into evidence and published to the media. Finally, we are going to be dealing with a lot of publicity when it comes to media coverage. And I think that's really where the remedy is going to be addressed. I understand there may be a remedy that can be fashioned today to prevent this kind of thing going forward or going on in the future in this hearing. But I think ultimately that's where this will be addressed. Any other questions from me, Your Honor?
Well, not at this time. I will afford you the opportunity, obviously, to respond when the defense comes back. I want to weigh this and taking in consideration, and I find your representations to be accurate as to what occurred. I believe that I noticed it and asked for it to be taken down because I have a live stream on my screen for that very purpose. And the sequence, I believe I made note, and if I'm wrong, please correct me. It's been a long 4 past days, but that's the only addition that I find to the representation. And certainly, Mr. Novak, feel free to correct it if you believe the sequence was any different. I just want to make sure a clear record is being made of what happened in order for whatever happens next to be appropriate and proportional to the actions that occurred.
No, and that's consistent with my memory. And I also reviewed the video, the live stream as well in preparation for this issue today. So that's exactly what I think happened. From my perspective, examining the witness, I did not have a view of what was being published to the public and the media. And so I think the court immediately, as soon as it recognized that, brought that to everyone's attention.
Thank you, Mr. McBride. To the media.
Good morning, Your Honor.
Good morning.
Appreciate the opportunity to be here to speak on behalf of the media. I think our understanding of what happened is consistent with what both the defense and the state have said here. So I don't want to belabor that point. But here's how I understand it. There's 2 exhibits at issue. Those exhibits were used yesterday in part because the juxtaposition of those 2 exhibits might have provided some sort of benefit to the court. The first of those exhibits was asked to be published through all 3 of the court's phases. The court said it will be admitted into evidence, be shown in the courtroom, will not be shown on the cameras. That happened about 3 hours into the hearing. That all went smoothly and well. That operated exactly as it is intended to. That requires the participation of everyone, the court, the defense, the state, media, camera operator, all to do that well. Later in the day, when in the video I reviewed, this was about 5 hours into the runtime yesterday. The second exhibit that was going to be compared side by side was introduced. That also went through that 3-step process. In that case, the court said that that could be admitted into evidence, shown to the court, and then also shown on the cameras. So it was put on the courtroom cameras. At that point, there was what I think is a useful practice by the camera operator to wait a beat, because sometimes mistakes do happen, right? In that case, though, that was authorized. So the camera then panned to the screen, which is set up specifically for the camera operator to be able to capture that. examination on that exhibit began. Then, because the examination seemed to call for that juxtaposition, without much warning for anyone involved, the previous exhibit that was intended to be juxtaposed was placed on the screen. From, I think, a observer's view who didn't know where the testimony was going without warning. The camera operator, I think quite astutely, within seconds, recognized this is a different exhibit, and recalling the court's prior order, recognized I should pan off, and did within seconds. I think at the time that was happening, the court also caught that and said, let's not do that. Now, and that was the end.
I wish they were saying what exhibits.
I don't want to minimize that. I understand the point that Mr. Novak is making. We are operating in some ways on high wire, and we are trying to place as many nets as we can, and all the parties are working together to try to do that. But in the age in which we live, one of the challenges is that sometimes when something like that is placed on a live stream, someone can screenshot it, and like Mr. Novak said, if they want to put that for sale on the internet, then they can. That's why working together to ensure that even
Oops.
mistakes like that don't happen is critical. And the media has the media coalition that are given the opportunity and the benefit of being able to be here to run cameras and to take photographs have complete buy-in on that point. There are, of course, people out there watching a live stream that are not part of our coalition that we can't control. And that's why it's so important that we get these pieces right. I do want, without going too far into the evidence, to note not only that several lines of this exhibit are available publicly in the information, but that the full text, every word of that exhibit is contained in a search warrant in this case that was initially filed on September 17th. This is in the 4th District, but in a different court. Was held for 6 months, as search warrants often are. But then on March 16th, March 17th, was released in full. On page 7 of that search warrant is the full text of this exhibit. I don't want to suggest that anybody gets the right to say, well, I think it's public. The court has said don't show it in the screen. But since I think it is, we'll just come back later on and tell the court it's not a big deal because it's already public. That's not how it works. If we say we think it's in the public, the court says, I understand that, but I'm going to make an order. That order should be adhered to. But I do, for the purposes of prejudice, for potential remedy, for the court's concern and the court's sleepless nights, I do want the court to know that as well. And members of our coalition have pointed out to me as we've talked about this, while we take this very seriously, it is true in this case that the full text of that, not the image of the exhibit itself, but the full text is already in the public sphere, has been reported on, and is out there. I only want to reinforce, to close, the recognition that the media, our coalition, I, as an attorney for that coalition, have an obligation to make sure that mistakes don't get made. And in this case, even though I believe that the camera operator didn't act in violation of the court's decorum order, didn't do something that was forbidden by that there was an order that said, don't publish this exhibit. And because it flashed on the screen when the camera operator was filming that screen, that did happen. The media is fully bought in. I, as one of the attorneys and the other attorneys for the media coalition, are fully bought in on a goal to make sure that this kind of thing doesn't happen. Of course, I understand Mr. Novak and the defense's need to make a record and make an objection. And I also recognize and appreciate and understand the court's role in trying to make sure it imposes whatever sort of direction, caution, sanction, response that it believes is needed to make sure that its orders are recognized and adhered to. And I want the court to know that we will understand that and will comply with whatever it is that the court orders.
Thank you. Anything further before we break? Mr. Novak?
We don't need a break.
Okay.
We don't need a break.
I want to review this. I'm sure there is a stream out there. I want to look at it again in order to appreciate the full effect and exposure. I remember it, but given the nature of this and trying to weigh the constitutional rights of all parties, I want to be thorough and look at it exactly. So as we move forward, as I evaluate what's being requested by the parties, that I am at the level of knowledge and because what it is, it was on screen. I want to look at it, how long, what exactly was on screen.
He's going to be looking for streams.
At the point of saying, okay, I fully understand. I mean, I was here, I saw it, I noticed it on the screen, but again, I want to take that extra 2 minutes to review that.
I'm not suggesting that we rush through this at all. I just wanted the court to understand that our request for the remedy and the sanction, we are prepared to share that with the court, but we can certainly wait until the court has had an opportunity to review whatever the court thinks it needs to review. The permanence of this violation of the court order is a different issue from how long it took to correct the violation. It's a permanent consequence. In other words, that image is out there forever and ever in violation of the court's order, no matter what actions the court, the state, and the media took to remedy it, because that's the technological world we live in. So that's my response, if I may, to the arguments. But we can hold our suggestion until the court's ready for it.
All right. If the parties feel it'd be helpful to confer while the court is reviewing it, you may, just so that if you choose to, I encourage it. If you don't, I respect that. A court's going to take about 5 minutes. Again, I just want to review it, to be brought up to full speed and just to have it freshly in my mind.
I'm going to make one more point, if I may, and that is, this is not the first time that this has happened. We had earlier proceedings in this case where the cameras depicted images inside the courtroom that the court had prohibited, and the court imposed certain consequences on the media as a result of that. And so that's just something to keep in mind, in my opinion, if I may. Thank you.
All right, before the court takes a 5-minute recess and to review this, does any party need the benefit of the record based off the dialogue between me and Mr. Novak? All right, not seeing any party respond. The court's in recess. We'll come back at 9:45. Court is in a brief recess.
Okay, so a couple things. I'm going to run through super chats as well, but a couple things I wanted to show you, and I'll keep this. I guess I'll just I'll just read it to you then, so I don't pull this off screen. And we do have Webb, by the way. I'll show you. I got Webb. Kevin from Webb is going to come on in a little bit, and when we have a break, he'll show us what some of this is. But I wanted to show you, because they've got Tyler Robinson inside of Webb, this whole trial and stuff. So we're going to get to check this out. Real quick, though, what is actually the issue here? I'll just show you real quick. So this is a list of all the things that happened that they basically leaked. The partially burned note. Let's zoom in here. When I zoom in here's a list of punchy ticker updates. No, it's giving me ticker updates. I don't need that. Partially burned note, intact phone photograph, a clear legible photo taken by Lance Twiggs on his smartphone displaying the unburned handwritten confession before it was damaged. The 37-minute unredacted interview, segments of Lance Twiggs' raw police interrogation detailing how Tyler Robinson allegedly searched for an engraver tool to customize the ammo, the assassination audio, the raw unshielded audio track from cell phone videos capturing the exact moments of Charlie Kirk's shooting. This is restricted visual evidence, accidentally shown or broadcasted on the live feed throughout the week. So the assassination audio, FBI DNA swab metrics, close-up digital monitor captures of raw forensic serial numbers and lab metrics from the towel and the rooftop screwdriver. Man, they did show a lot. Rooftop laser forensic data, technical scanning maps and data charts mapping out the sniper's trajectory from the UVU campus perimeter. Well, that's a lot. Andrew Colvett now publicly questioning the extent of Lance Twiggs' involvement. Oh, is he? I'll have to go check it out. I'll go to his ex in a little bit. Sus Lynn, Wednesday shown twice. Yeah, I saw that. Thank you. Jen Common, I'm so desperate to hear from Tyler Robinson himself. I've said this many, many times. Many times. I think we haven't heard anything. We've heard nothing. The only footage we have of him speaking, I believe, is when he was pulled over by a police officer on body cam footage. From how long ago? Thank you. Thank you. Yeah, I saw the wheels are definitely different. I saw that. Thank you. What is happening September 1st? That's when they're going to decide if they're going to go to a jury trial. You're going to have to go back to the beginning of the episode to understand. If you need to go back and watch it, please do. That'll explain. You have to watch. Basically, what it is the judge is going to make its decision on behalf of the court. I don't know why my camera keeps on behalf of the court on September 1st. The defense and the prosecution have their time to submit their portion. So it's basically like a preliminary hearing on paper to finalize everything. The defense is going to counter every single thing, hopefully, whatever they need to. And that's what's going to happen. So September 1st. So we're not going to find out anything today. We're not finding anything out today. Cash Padel show. I think they suspected I think the suspect talked to Dan Flood about the people standing on the walkway above. Dan's text to the chief is faked. It was on the 10th. Interesting. The one where like we've got you covered and all that. I think the suspect talked to Dan Flood. Interesting. Okay. I'll screenshot that. Take a look here. Let me put that in my notes. Kevin, we have the Tyler Robinson court transcripts in Webb. Ooh, that's massive. Sweet. I was talking to Kevin. All right. Gen Common 9099. I won't upgrade past iOS 17 to avoid Apple on device AI in iOS 18, which also allows the auto text, schedule text. This means Tyler Robinson's phone had this AI software. Now, who created Pegasus and loaded it on phones? His phone doesn't look like a phone that has AI software. I'll tell you that much. Thank you for the super chat. The Rileys, good to see you. $5. OMG. What if Tyler went to warn the TPUSA team and he knew what Lance and the feds were going to do, not realizing TPSA was in on it too? No, that'd be terrible. Imagine you go to try to save someone's life and you end up in prison for their murder. Oh. Are they trying? Helga Shabalaba Ding Dong, $9.99. Are they going to try to take the cameras out of the courtroom because of this? That is an interesting question. They could easily use it as a like, you know what? But that's a really bad look if they do that, because it shows severe incompetence on all parties. The media, they're not on the knowing of. They should know what is not to be shown to the public. Whoever is giving this stuff to them to show, they should know this should not be shown to the public. I mean, what is this? What are you talking about? They should all be aligned with what's going on here. Hopefully I'm on time. Okay. Thank you, Helga. The Rileys again, $5. Because then they were looking for him from the start. He was made Patsy to cover up the crime. All other stuff makes so much sense if that's true. Because then they were looking for him from the start. He was made Patsy to cover the crime. Oh, yeah, for sure. I hear you. I hear you. Amy, good to see you, dear. $10. They can just time lag the live. They can just time lag the last live streams, right? I don't quite understand what you're saying. But the way I understood what was going to be happening here is that the judge, they must have maybe found, or they're going to go look and see if there's any, if there's anything going on. Someone said court is back. I don't see court isn't back yet. I'm just looking at some dude's hair or some chick's hair. That is like very high def though. Look at this. We got a really good shot of that hairdo. That hair, man, it's clean. Look at that. Oh, yeah. He's got some sweat. Oh, no, he's not sweating. Glistening. The light in the is creating an ambiance. The ambiance in the room, even though that light is on, it looks very dark. I don't know if it's doing that good of a job, but there's a light. So anyways, enough kidding aside. Do you like this version, the square or the rectangle? Can you let me know? Or should I go circle? We got a circle here too. We could go circle. Let me see. Should we go circle? Go full circle? Let me see. How much can we get if we go full circle? Let me try this. If we go full circle, can I get the whole thing in? No, I think I have to go like this. Let's try it. I'm going to see if I can get this whole screen. It's almost full screened. And then I can come in down here on the, ooh, this is kind of cool. This is kind of cool. I might come in on the bottom right. Let's see. We'll mess with this for a bit and we'll see what we end up with at the end of everything. But this is pretty good. We've got full screen here. Looks pretty clean, no? Yeah, that looks clean, bro. I'm feeling that. Yeah, I'll mess with that. I'll play with that. All right. So they're arguing, is the information basically, I think he wants to know how to proceed, right? I gotta figure out, I don't know if there's someone smarter than me at this stuff that's covering it right now. Let me see. Tyler Robinson hearing live. Let me see if there's anybody that can give some quick commentary on any of that. I'm just looking through to see, is there anybody live right now? Let me click the live. Is there a live button somewhere? I don't want to miss the did I leave the court?
Call up here.
Whoa, where am I?
And you
Where
can
am I?
see down here, there's two.
Whoa. Chilly Willy. All right. Yeah, circle is pretty clean. Left or right? I think the right is, I usually don't do right. We could try left. I don't mind. I think that kind of covers the text. So like the right seems kind of clean. I guess we'll see. I'm kind of interested in this tool here. I wish you guys could see if I split. You can see it if I share the screen like this. Here, let me see. If I share this whole window right here, you could see that I have Webb up right here. Bam. And so I got the monitor. I'm watching the show or the court. And then we've got Webb. I'd have to make myself a little smaller. And then probably move myself. Let's do that. All right. So Tyler Robinson trial. What can you show me? Let's find out. What can you tell me about the data set you have? Let me answer this live chat. Amy, they could like 3-second lag future live streams. LOL, damn fingers. They could probably do like, yeah, they could do like a 60-second, like latency. It's called latency. So they could have high latency. Normal latency is like low latency. So what we have right now is low latency. So when I talk, you get 3 to 5 seconds. I think it's 5 seconds of lag time. So they are already doing that. Probably, I would assume there's at least some latency. Ultra low latency is not common and it uses a lot of bandwidth. So I would assume that they are using I assume that there's already some, but you would need more like a 3-minute lag or a 5-minute lag to really, but that throws everything off. If you even do a minute, that throws the whole thing off. So we want to see what's happening live. If the people in the courtroom saw, but not us, how do you think that is for us, right? If they see it, that's the public. Oh, just because they were there, they got to see it? No, we should all see it. If it's a mistake, we all end up seeing it. So we just have to hope that they don't use that as an excuse to make sure that we are not pulled away from having an opportunity to see everything. All right, let's see what this Webb thing can give us. I'll have this up a little bit. Well, I don't want to play music. So I said, what can you tell me about this data set? Here, I'll zoom in for us. Here, I'll make it bigger as well. And I'll go full circle. All right. Let me start by exploring this data set to give you a clear picture. So this is the Tyler Robinson trial. So when I go back, it's got all of these, all right? Mr. Epstein, Erica Franzby, twin sisters. I think that we can actually publicly upload our own and even make it a part of the website. I don't know. I guess we'll find out in a little bit. But you can click the Tyler Robinson trial, which I have. I'll open it. And what this data set contains, this is the complete court record. Here, I'll zoom in. This is the complete court record for State of Utah versus Tyler James Robinson, 4th Judicial District Court, Utah case number 251-403-576. The prosecution of the man accused of assassinating conservative activist Charlie Kirk in September 10th, 2025, Utah Valley University in Orem. So this has 310 documents, 5,145 chunks of extracted text, spans from the initial charges, September 16th to 2025, through at least April 2026, covers a capital murder case where the prosecution is seeking the death penalty. Examples found, there's court filings, dockets. So there's a lot of stuff. And Kevin told me, he said, you could basically look at anything we wanted. So we could definitely look at stuff while we're live if we want on the side. I can do a window like this for us. So if anybody's curious, we could definitely do that. Be like, hey, can you search in Webb for that? Maybe I will. Or if I think of something as well. I sent Kevin the link. He might join up. So I'm down to mess with that. Let me see. I did want to... Give me 1 second here while we wait. I wanted to look. Well, here we can look together. Wanted to go to YouTube. Let me make sure we're not missing out there. I wish you could add 3. I don't think I can. But let me see. Somebody right now covering like a quick breakdown that's smarter than me, but I don't know. I think it's all just broadcasting. The Christian Post, Court TV, 21 hours ago. Yeah, it's okay. Dig deeper. The ATF couldn't match the bullets. Okay. I'm curious on what happens. Yeah, I'm kind of curious on the level of the others of you. Where it's here, I'm going to pull up my Claude actually. Let me do this. I'm going to pull Webb away for a second. And I'm going to do this one with this. And then we're going to go to Dankster Socials. Boom. What happens to the case? What happens to if the preliminary, it did, hearing was shown evidence that the case wasn't supposed to show? Prosecution. And then I'll copy, I think it was this, right? So I'll just kind of copy all this. Yeah. Copy that. See attached. I think it's attached. Let me know if they would use it as a cause to get rid of cameras. Let's see what Claude has to say. I feel like I'm too small. Could be just me. I got a size issue. So the straight answer, then a hard flag on that document because half of it is not verified. That came from Google. The legal question, would an accidental broadcast of restricted evidence be used to kill cameras in the courtroom? It says yes. Let me make it a little bigger. That's exactly the argument. It's a strong one. Here's the mechanism. Judge Graf spent this entire week building a tiered publication system specifically to protect Robinson's fair trial rights, redacting the Twiggs video, keeping the note off the live stream. The whole legal basis for the caution is the Sixth Amendment right to an impartial jury and the controlling precedent the defense already invoked, which is about how pretrial publicity and cameras can taint a jury pool. So if restricted material actually hit the public feed by accident, the defense's move writes itself, Your Honor, the court built safeguards precisely because this material is prejudicial. The safeguards failed. The only way to guarantee they don't fail again is to remove the cameras. An accidental leak is arguably the single strongest fact a defensive can have. The counter pressure, media coalition, First Amendment access, Kirk family through Neiman, who's been pushing for more transparency all week. Yeah, but since they're in the court case, I would imagine I don't know. I don't know about Neiman. And the general presumption of open courts under Utah's rules, Graf already showed this week he prefers the scalpel over the sledgehammer. He redacted rather than closed. So the realistic outcome isn't necessarily a total permanent ban. It's more likely a tightened protocol, a broadcast delay. Hey, there we go. Shout out to Jen. A killed evidence monitor feed, camera repositioning, or temporary suspension for the sensitive portions. A full permanent expulsion is on the table, but it's the maximal ask, not the likeliest ruling. Bottom line for your audience, an accidental leak of protected evidence is legitimate, powerful ammunition for restricting or removing cameras, and the defense would be committing malpractice not to use it. So this would come from the defense. Whether Graf goes all the way to ban or tighten up protocol is the outstanding open question. All right, so let me pull back up the window. I think we're getting right back into it here soon. And we are live, right? Yep. Well, if you're not a member on YouTube yet, you definitely might want to join. We have members only live streams every Saturday. Tomorrow morning, we will be having a live stream at 10 a.m. Pacific. And you can also join ClubVatra.com and go to Dankster Intel, join my community, our community. It's more, I'm just part of it. We have over 100 people in there that are regularly doing research, investigating, and we do weekly calls as well on Wednesday. I missed this week because of the court case, but we'll reschedule. Anyways, join us Saturday for 99 cents as a member, or join us on ClubVatra, which takes you to Discord. Let me run through some of these comments. What do we got? Anything in here? Oh, yes, just in time. It's actually Dankster Intel, but real Dankster does get you there. What do we got? That note was supposed to be burnt. Even Cash said they had ways of finding info on it. Yeah, that's crazy. How can you find info from a burnt image? That doesn't even make sense to me. Let me see on X here. Let's see. I haven't been on X all day. What's on my homepage? Bays update. Tyler Robinson trial preliminary evidence. I'm really trying to be objective here. I'm not in denial that Tyler Robinson did this, but the evidence. Let me. I'll keep this open on my side here, so I can see it. What does he say? He says, I'm not in denial that Tyler Robinson did this, but the evidence was extremely oversold and based on a gunshot wound with such a low probability that after all of the uncertainty that was promoted by the DOJ, mainstream media, and TPUSA itself, I expected a lot more than what we got. I agree, 100%. This is from Bays. If you don't know Bays, at Real Bays, go check him out. Good dude, good content. I've been analyzing the footage, and images of the car they said was Tyler Robinson's at UVU. and I'm trying to do so as objectively as possible, but I can't get over this. The front of the car just doesn't match. Even ChatGPT confused it with an SUV because of the poor image quality. I've been doing some research, and it looks like the car they're claiming was Tyler's at UVU has a modified front end. Below are a few pictures of that car, Tyler's actual car. The car they're claiming was his, and images of the modifications that align more with the car scene at UVU. I want to know what you guys think, and if anyone has more info, they can help improve anyway. So what I see is that there's a hood scoop on this car. I don't know what this is, a bumper scoop. I don't know if I've ever even seen one. So a bumper scoop, it doesn't stick out. See how this is the natural bumper scooper. I don't even know what the hell to call it. But then look at this. This sticks out. Unless this looks like it's sloped out and it runs like, imagine the front of like this is my phone. But imagine this is like my phone, right? And it's flush. But this thing actually looks like it has something that sticks out like this. Like that kind of sticks out and it runs further out than you would from the top of the hood. That's what it looks like. There's a scoop underneath. And don't worry, I'm keeping an eye on it over here. We're not live yet. So that right away, and then there's different images that say the tires. This is from, it looks like maybe his ChatGPT. This crop provides a frontal 3/4 view of an SUV. That's just, I wouldn't have posted that personally, but that's just AI being AI. There's other things, especially the rim size for me. But it's hard to tell from just this side image. I'm not sure what this is. Okay. Here we go.
What do we see now?
That's the vehicle exiting with.
What do we see now?
A windshield sticker? This to me looks like.
That's the vehicle exit.
Oh, yeah. It has a windshield sticker. This camera view is the only time we see a windshield sticker. Interesting. What is that sticker doing right there? It's kind of a weird spot. Is it not just the, it could just be
We see now.
like, the visor. It looks like it's just the visor, but maybe not. What is that? Anybody know what that is? Interesting. I'm just scrolling through on X now. Sam Parker. So let me get this straight. And we're waiting for the court case. It's still right here. I'm just waiting for it. Don't worry. So right now, what we're experiencing is, or what we're waiting for is the judge to go through and figure out really what was shown to the general public that wasn't supposed to be shown. And has he already kind of prejudiced the jury? I would say absolutely. Absolutely, the jury has been prejudiced already. It's been a long time coming. However, we're not, this is America, man. You guys chose to do this. This is what it is. I think we're coming back. Here we go.
Presence of counsel and all parties. And where we left off is the court took a recess to review the video. And I appreciate the patience of the parties as well as everyone in attendance when it comes to constitutional matters and balancing constitutional rights and transparency. This court will take the necessary time to make sure it's given the weight it deserves, and it is deserving of every moment that has been spent. Mr. Novak, turning to you. And perhaps before you begin, let me go ahead and make a record of what I noted that is at issue. And after I put this on the record, certainly if either side wishes to be heard about the court's understanding, I welcome your comments. Exhibit 24 was displayed on the monitor visible to the media camera. Exhibit 16 was displayed on all monitors and appeared on the live stream for approximately 3.5 seconds. The camera operator redirected camera before any party called attention to the display of Exhibit 16. Approximately 16 seconds later, the court observed the image and stated, "Let me stop you, Mr. McBride. I'm not sure. Is this being broadcast?" Mr. McBride responded, "Let's take that down." The full text of Exhibit 16 had previously been made public through a search warrant that was publicly available on or before April 2026. The portion displayed on the monitors did not contain the full note and consisted of approximately 78 words. Approximately 15 of those words were included in the information filed on September 16th, 2026. In addition, the full note was read into the record during the preliminary hearing. The court previously ordered that Exhibit 16 be admitted into evidence and permitted its display within the courtroom, but prohibited its publication through the camera used for the live stream. And that concludes the findings of the court as it relates to this issue. Do the parties wish to be heard before we go into what you're requesting about the record on what occurred?
Your Honor, your recitation is accurate. My earlier comments were based on my memory of reviewing this last night. In the recess, I reviewed the feed again, and what you have said today is accurate.
Thank you. Mr. Novak, any?
No, Your Honor, I don't take issue with the court's factual summary.
All right. Turning to you, Mr. Novak.
Thank you, Your Honor. We're going to renew our request to exclude all electronic media coverage from all future proceedings. That was our motion docketed at number 305, and that included video cameras, still photography, and audio. This is the second time that the court's orders concerning the scope of electronic media coverage have been violated. I'm a baseball fan, and I just don't think the court needs to wait for the third strike. 2 strikes is enough. If I may, the alternative remedy, which we think is not wholly adequate, which is why we think it's an alternative and a less desirable alternative, is for this court to both reverse its prior order authorizing electronic media coverage of today's hearing, which we had previously filed an objection to after the court, I would say preliminarily granted the request for today. That was sort of the chain of events. And that the court proactively preclude electronic media coverage at the last day of the preliminary hearing, which will be September 1st. Now, I understand that there has not yet been a request for electronic media coverage for September 1st, but there is no doubt that there will be, just as this court previously observed that it wasn't prepared to preclude electronic media coverage at the preliminary hearing because there had not been any requests. There were requests, and those that were timely were all granted. The court denied one request because it was not your day. So I guess the way it would be is any request for electronic media coverage of September 1st will be denied because that's the appropriate sanction for what happened yesterday. The fact that the content of the exhibit was previously summarized by the state in certain documents which became public because the state didn't take any actions to seal them beyond the 6-month period. The fact that the contents of the exhibit were read in open court is not the issue. The issue is when the court issues an order, everybody must comply with it, and there are reasons for the order. And the reasons, as this court stated, are to protect Mr. Robinson's right to a fair trial. So no doubt that the court balanced those prior ways in which the content of this exhibit had already been disclosed when the court decided that there would not be electronic media coverage. That's the fact that we have all known of that exhibit. That's a fact that we've all been aware of as we've gone along. So to summarize, and then I will stop because I know we still have a witness here. And of course, the court needs to hear from the state and counsel for the media, I suspect, is we would like the court to reconsider its order denying motion 305 and grant it for the balance of all of the proceedings in this matter. Or as an alternative, the court prohibit any further electronic media coverage of the preliminary hearing, which includes September 1st.
Thank you, Mr. Novak.
Thank you very, very much.
Turning to the state and then to the media.
Yes, Your Honor. As to the remedy, we've heard of instances where the media has been able to delay publication of the recordings of the proceedings. We've heard of instances where that has been a short delay of like 30 seconds. I've talked to the media attorney about
gonna get a delay in audio. 1 second.
To do that right now. My suggestion would be for future proceedings to here order the media to look into that capability, and that would be a remedy that perhaps could be used in the future. I think that would be a satisfactory remedy to avoid this type of thing in the future. As to the other remedies requested,
Everything's okay. You can still hear it, right? I changed to my Bluetooth speaker.
one witness.
Echo, I'll mute it.
The final witness, well, the defense has one witness. That witness is a ATF DNA forensic biologist. And I assume that the exhibits that will be admitted through her will be of that nature. We've already, in fact, admitted.
Saying echo. What are you guys saying? Everything okay or what? Here, let me stop it and start it.
Report that she is going to be testifying to. The reports, I should say, that's exhibits 30 and I believe 34. And so I don't think we have, and those have already been published. I don't think we have the same risks or, I'll just say risks with her testimony as we do with some of this other evidence that has already been admitted.
Thank you. To the media.
In a proceeding like this, the parties in the court and the media are working together to learn and to refine their processes. I hear Mr. Novak's remarks about challenges that we've run into in the past. I recall, it hasn't been that long ago, a time when the camera was placed in a location in the courtroom that was causing challenges. The court moved it. When there were challenges with aspects of the court's ruling, the court reiterated those, and those processes improved. We are getting better at this. Media is on board and recognizes the court's obligation and its significant efforts to balance the interests here. In light of the court's ruling, including its recognition that the media operator in this case beat almost all of us to the punch, right? And saw what was happening on the screen and moved away as quickly as they could. We believe that the procedures that the court currently has in place, even if they don't every moment of every hearing deliver the result that we are intending to deliver, those processes are working. I don't believe that a further adjustment, much less a sanction, much less a revisitation of something that says let's keep every photographer, every camera out of this courtroom for every proceeding. In light of the court's well-reasoned and exhaustive rulings after long briefing on all of this, the court is currently balancing these interests correctly, and we therefore ask the court to allow the parties to recognize that the time we're dedicating this morning represents a reiteration of the importance of these principles. The media and the parties all recognize that. We'll continue to endeavor at all times to do all that we can to ensure that those are adhered to, and let the parties go forward under the current procedures without further order or sanction by the court.
Thank you. Any further argument?
Every time he comes up, the judge just was like, "Thank you." That's it.
And I'm just updating my notes as I'm intending to issue this ruling right now. I'm just making sure that I'm capturing all the points made in the argument right now.
That'd be crazy, bro. Looks like the state knew, yeah. State knew this was going to happen. He's typing in the chat. What do you guys think we should do? What do you think? Live stream it or not? You guys are over here blowing our cover. He's like on my X account. He's like, this is so messed up. This guy's got everything. He's got everything. He's got all the, oh my gosh. He's texting right now. Who's he texting? Elon? He's like, yo, Elon, we got to take care of this dude right here. Free memberships, Judge. You can join. I'll give you ClubVatra, top tier. We can talk, whatever. You got whatever you want. You can join. Come on, bro. I got you. It's Kevin. What's up, bro?
What's up? How you guys doing? Thanks for having me,
bro. Yeah, just watching the judge deliberate and put in information. We were joking that he's in the chat, and he's because right now they're going back and forth. Yeah, well, because they're arguing about all these things that they showed to the court they weren't supposed to show.
Yeah,
and they're like, well, people could have screenshotted it, and I was like, oh shit, I screenshotted everything that they weren't supposed to put out. So we're joking like, oh, he's on my X. He's like, damn it. And he's sent it someone.
Yeah, I guess they've like accidentally released and like doxed people and like released all sorts of not public information through this. It sounds like a fucking shit show over there.
Yeah, it's been a little wild.
A little shit show over there in Utah. No, but yeah, man, thanks for having me on. You know, so we just dropped, for those that don't know, I'm one of the owners of Webb with Ian Carroll. And we put all of the transcripts in for the last 4 days. Today's transcripts, when they dropped, will also go in. And those transcripts will be in Webb forever. So you can go in and actually look at everything, including videos. It'll bring you to videos. And my dev actually just texted me and said that the videos that we use, we even go so far as to give those clicks and views to local news stations in Utah and not like CBS or NBC or any of these big fucking things. So if you're in Webb and you're clicking on videos, you're actually giving those views. What's
keep
that?
The F-bombs low. Keep the F-bombs down since we're doing the trial hearing.
Oh, sorry, guys.
You're good.
I'm from Boston. I kind of do this. Yeah, somebody asked if this is what Ian created. Yes, Ian and our team, we did the Webb. But it's really cool. So you can ask questions. You can get real conversational with it.
Let's see what he's saying.
Yeah. And as my practice. I don't like to rush.
Oh, he was
snap
saying that.
decisions, and I want to give this the full analysis that it's due. So
Yeah.
thank you again for your patience.
He seems to be care. Have you been following this at all?
A little bit, but not. I'm not super up to date.
Yeah, the court volume is low because the judge he's just kind of talking to the side person, saying he's not talking into the microphone, but he was basically saying, I want to give this my full effort. Thank you for your patience. I want to make sure that I'm doing this properly. You know,
Good.
I don't want to rush anything. So people are asking, like I'm saying, guys, it's not, he's not talking. The microphone is over here.
All right.
Here he goes.
Court will issue its ruling on the request by defense. The constitutional rights of Mr. Robinson and Ms. Kirk are paramount. Although transparency in judicial proceedings is a fundamental interest, it must be balanced against the constitutional rights of all parties. Having considered the arguments presented by counsel and having reviewed the events that occurred yesterday, the court finds that its order prohibiting the publication or broadcast of Exhibit 16 by the media camera was violated. The court agrees with the defense. This constituted a violation of the court's order. Compliance with court orders is essential in all proceedings and is of particular importance given the nature of these proceedings. With respect to defense's request as a sanction that the court reverse its ruling on defense motion 305, motion to exclude cameras, the request is respectfully denied. The analysis underlying the court's prior ruling remains unchanged, and the court adheres to its reasoning and conclusions. With respects to the defense's alternative request as a sanction to prohibit all cameras and electronic equipment from today's proceedings, thereby preventing the electronic capture of the proceedings for those inside and outside of the courtroom, the request is granted in part and denied in part. Effective immediately, members of the media shall no longer capture or broadcast any exhibits displayed by the parties during today's proceedings. The court finds this sanction to be proportional and appropriate in light of the violation of the court's prior order. The court reserves this sanction as it relates to September 1st. It is not before the court. There has not been a request for electronic media coverage, and the court won't issue a pre-ruling. When it becomes, that request has been filed and all the deadlines which the court has imposed in regards to the MC filing are in place, if motions are filed, the court will entertain motions in brief argument ahead of the September 1st hearing and address it at that time. This is the ruling of the court. Thank you. Turning to the defense, if you wish, you may call your next witness.
We would like the benefit of the record before we start taking evidence today.
Yes, Mr. Gernander, and I'll allow all parties, given the ruling of the court, briefly.
And I'll be brief, Judge. And this is in relation to the continued taking of evidence today. And I'll start my statement, Judge, with something that was very insightful that you said the other day. You mentioned, and I quote, "Sometimes you need to take time to save time," close quote. And so that's my purpose for standing up here this morning. We have spent the better part of a day, a little over 5 hours, I believe, hearing from witnesses that the defense has called at this preliminary hearing. And no doubt the defense is entitled to call witnesses at a preliminary hearing as allowed by the rules. But I think it's important that the court remind all parties about the purpose of this hearing. This is a probable cause hearing, as Your Honor has repeatedly stated. The defense has invoked the term reliability many times. And the court, frankly, has found the evidence that's been admitted, the testimony. As a gatekeeper, the court has found it reliable. It's been presented. The exhibits have been found reliable. So any questions of additional reliability are really questions of credibility of the witness and weighing of the evidence. And that is not really what this court engages in at the probable cause standard. And so this is all couched in the context of a likely forthcoming standing objection that the state may lodge.
If the testimony is long and drawn out and exceeds the scope of the preliminary hearing, gets into areas of a 702 hearing, possibly even trial, we will lodge this objection. But I wanted to just simply state the authority, Judge, behind our objection if we do make that. As your court is well aware, the magistrate at this stage of the case must view the evidence in the light most favorable to the prosecution. And that's cited to in a number of Utah cases, to include State v. Schmidt. Schmidt continues, this means that when reasonable inferences from the evidence cut both for and against the state's case, the magistrate lacks the discretion to choose between them and must leave such a determination to the fact finder at trial. A few other cases I would like to refer the court to. State v. Pledger, which is a Utah 1995 Supreme Court case. Speaking of this standard, the court says, the standard bars the magistrate from requiring the prosecution to address or even eliminate alternative inferences that could be drawn from the evidence in favor of the defense. So even assuming the defense scores points today in calling these witnesses, again, the court cannot really weigh those in favor of the defense. State v. Hester, which is a Utah Court of Appeals case 2000, where there is conflicting evidence, quote, the magistrate may not sift or weigh the evidence, but must leave those tasks to the fact finder at trial. Of course, we're not at trial yet. State v. Virgin, a Utah 2006 Supreme Court case, indicates that a magistrate may only disregard evidence at a preliminary hearing if it is, quote, so contradictory, inconsistent, or unbelievable that it is unreasonable to base belief of an element of the prosecution's claim on that evidence. There's a State v. Drozbecki case, which is a Utah Court of Appeals case 2010. Magistrates may only disregard or discredit evidence that is wholly lacking and incapable of creating a reasonable inference regarding a portion of the prosecution's claim, but must leave all the weighing of credible but conflicting evidence to the trier of fact. And finally, State v. Lopez, a Utah 2020 Supreme Court case. Speaking of this probable cause standard at a preliminary hearing, the court said, under this low bar, it may be difficult for the defense to overcome a prima facie showing of probable cause. Even an alleged victim's recantations may sometimes be insufficient, given that the magistrate must view all evidence in the light most favorable to the prosecution and draw all reasonable inferences in favor of the prosecution, close quote. Judge, Your Honor has heard 4 days of testimony now. The evidence is overwhelming. It's devastating. And the question needs to be asked, the purpose of continuing with testimony if it's long and drawn out. Of course, the defense has the right to call witnesses, but it needs to be within the context of this preliminary hearing. So again, we may be lodging a standing objection of relevance and exceeding the scope of this hearing. That's my record.
Thank you, Mr. Grunander. Do other of the parties wish to be heard as it relates to Mr. Grunander's statement? To the defense?
I'm not sure what was being requested by Mr. Grunlander. As I indicated to the court during the testimony of the last witness, we had discussion with the state prior to the start. We had a scheduled date for the court to rule on objections. And the purpose of that hearing was so that we wouldn't have to fly witnesses out from the East Coast if there was going to be a standing objection. Prior to that hearing taking place, the state contacted us after they had participated in interviews of Miss Oliver and the other experts, and indicated to us, and we indicated to the court, that there was going to be no standing objection to the testimony of these witnesses. So if he's lodging a standing objection now, I think he's waived it, or he should be stopped from asserting it given the circumstances. I didn't hear that he was asserting that, and I intend to keep this next witness focused on the issue that I think is relevant, which is the state presented DNA reports through a non-expert. They selectively read into the record a portion of those reports, which left an extremely misleading impression of the significance of that evidence. So I have the author of the report here, and I'm going to hopefully educate the court on what the limitations are of the report and that's it. I hope to be done with the witness by noon, direct and cross, and that will be the end of it.
All right, thank you, Mr. Burton. And before I have you call the witness, just want to make sure that the media had I'm not sure if the media needs to be heard on Mr. Grunander's response. All right, thank you. All right, Mr. Burt, you may call your next witness.
Thank you. Call Miss Oliver.
Ms. Oliver, if you'd like to come forward and be sworn in.
You do solemnly swear that the testimony you shall give in the case now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
All right, ma'am, you may be seated. And there's a water bottle to your left if you wish. And after you're seated, if you wouldn't mind adjusting that microphone, bringing it close to you to pick up your testimony from today. Mr. Burt, your witness.
Thank you. Could you tell us your name, please?
Caitlin Oliver, Oliver.
And Miss Oliver, could you bring that mic a little bit closer? So I want to make sure your voice is projected. Thank you. What do you do for a living?
I work for the Bureau of Alcohol, Tobacco, Firearms, and Explosives as a DNA section chief.
And how long have you held that position?
I've been a section chief since January, and I've worked with the ATF for about 9 years. Prior to that, I was a forensic biologist.
And where were you a forensic biologist before you started to work for the ATF?
Prior to the ATF, I worked for Jefferson Parish Sheriff's Office in New Orleans, Louisiana, as a DNA analyst and a DNA quality manager.
Back in September of 2025, what were your duties and responsibilities?
I was a forensic biologist.
And do you recall that around September 11th, you received a request to do some DNA work at the request of the state of Utah?
Yes.
Could we display State's Exhibit 30, which is in evidence?
Court cases are very riveting.
Are you joking or not?
I'm definitely joking.
So, as we understand it, the judge is allowing video footage, and there was a part where he said that he was going to make some changes, but didn't seem like any adjustment to media coverage.
Well, these guys should be like streamers and show us the fucking videos.
His mic is off, by the way, so you guys. Yeah, they should show us everything, but they don't want to prejudice. I don't understand showing some, not showing the rest. It's like, I don't know. I feel like it's you might as well show everything.
Agreed.
You might as well show it all, I guess, if you're going to show pieces here and there. And
it's a trial. Who are we protecting? Protect victims. Other than that, everything should be open, man. All court cases, I think.
Yeah, I agree. What's up, Zero? I'm betting tens of thousands of people get a lot leases done at work this week while watching. Oh, tens of thousands of people getting a lot less done at work. listening to the trial. You're probably right. Thanks for the super zero. Good to see you. Hope everybody's doing all right. Helga, thanks. I just sent you an email with my video from 9/10. Uh-oh. I'll check it out. Thank you. Man, he's like a statue.
Yeah. I hear this guy's been doing a great job, though. This judge. What do you think? You think he's been doing a good job?
I do.
Nice.
Okay, I'm reading your email, Helga.
For instance, the next sample down, 1.2, where the state read paragraph D, admitted paragraph F.
I need to turn the audio up.
Based on this calculation, there is evidentiary support for the inclusion of Tyler Robinson, correct? As a possible contributor.
Correct.
Mr. Burt, I just want to interrupt.
Sure.
I was made aware of a question about the media as it reflects this order. So the question was whether audio could be transmitted, and my ruling covered the video display of any exhibits. And so I just want to make sure that's the understanding of all the parties, that the audio of your portion discussing evidence is that you understand that that's going to be captured by the camera and displayed, but not any exhibits displayed. Is that your understanding?
That is my understanding of the court's ruling, yes.
And to the state?
Yes.
And to the media?
Yes, Your Honor. There might be concern about the actual monitors, the counsel table, and
Voir dire is the jury selection.
That's why I give my notation to begin the morning that the parties are responsible to monitor their monitors, and that's there because they're entitled to view it, but they're responsible to ensure that the monitors, as the camera is picking up the courtroom, it's directed not to focus on the monitors, but inevitable capture may occur, and that's why that instruction is given.
Your Honor, Jeff Neiman on behalf of the victim representative. We cannot see it in court from where we're sitting, so I don't know if there's a way for us to view the monitor.
I don't understand what you're saying.
It's not being published on this one.
Man, I don't know if they're doing it on purpose or not. We
Right.
can't hear anything.
The order of the court based as a sanction is no exhibits will be displayed.
In the courtroom entirety?
As it stands right now, yes, that's correct. Okay, please approach the lectern.
Your Honor, it's just hard for the victim's family to be able to follow the evidence if everyone but the victim's family is able to view the exhibits here in court.
Thank you. I appreciate your concern. This monitor is not on either. So it's only the attorneys. The attorneys have a right to view what exhibits are being displayed, to make their motions, objections, and to see it. It is the court's discretion on what's displayed in the courtroom for publication, and the court issued a sanction given the events of yesterday, and that's the court's ruling.
Your Honor, I just asked the court to consider the victim has the right to be present, obviously, at the hearing, and the presence without being able to see the exhibits, again, it's our position, is not meaningful.
Thank you. I appreciate your concerns. Mr. Burke.
Could you redisplay exhibit 30, please? And again, while he's doing that, that same conclusion where you include the language, go back to that page, please, 5. Use the term, there is evidentiary support and possible contributor. I want to focus your attention on the words evidentiary support. We've had a prior witness testify that from the FBI testified that they use a scale and they characterize the support along the lines of strong. Are you familiar with that type of a scale?
Yes.
Does your agency employ that scale?
We can come to 5 conclusions at our agency. So there can either be exclusion, limited support for exclusion, uninformative, limited support for inclusion, and support for inclusion.
And I take it from what you just said, you don't use these qualifiers strongly. The word strongly include things of that nature.
Yes, we don't use a verbal scale at our laboratory.
Is that a scientific phrase when you talk about instead of saying that there's support for an inclusion, you instead say there is strong support for the conclusion?
So our laboratory doesn't use a verbal scale due to the fact that they add subjective words to the front of this word support. It is our stance that the likelihood ratio statistic, the number stands on its own. So we report the likelihood ratio and either support for inclusion or support for exclusion.
Thank you. Would you go to page 8 of the report and highlight the very top of the first 2 sentences? You included this language in your report, correct?
Correct.
And in fact, you included this language in all 3 of your reports, referring to the conclusions conform with the relevant Department of Justice policy on uniform language.
That's correct.
Right. And why do you include that language in all 3 of your reports?
It's standard language for our reports. Our reports adhere to the DOJ Ultra statement.
Okay. And could you go now to Exhibit Oliver 4 for the witness only? Not admitted yet. Are you familiar with this document, the Department of Justice Uniform Language for Testimony and Reports for Forensic Autosomal DNA Examination using probabilistic genotyping systems?
Yes, I am.
Right. And would you go to page 4 of that document, please? And the court has heard some prior testimony about this Department of Justice directive. What is what is your understanding of what the qualifications and limitations are that are required by this policy of the Department of Justice? What are you not supposed to be saying in connection with the reports that you wrote in this case?
There's a few things that the Ultra document states. First, it states if you use a verbal scale, which we do not, then you need to use the one dictated in the document. This is in an effort to unify the language coming out of DOJ laboratories. It also says that we cannot state that our evidence is infallible, nor can we state that there is a inconclusive result.
Shall not state that it's infallible or have a 0 error rate, correct?
Correct.
It also states, does it not, that you shall not assert that a likelihood ratio of any magnitude provides an absolute identification or source attribution of an individual to an evidentiary sample.
Correct.
And are your reports in conformity with that? You're not stating or implying that anything you did here is asserting an absolute identification of someone as the source of any of the evidence that you examined, correct?
Correct. With forensic evidence, it's impossible to state with 100% certainty anything. That's why we report a likelihood ratio to speak to that uncertainty with a statistic.
All right. And would you go to the next page of that document? This policy requires that you not state or use the expressions reasonable degree of scientific certainty, reasonable scientific certainty, or similar assertions of reasonable certainty. You didn't do that in any of your reports, correct?
Correct.
You're not asserting anything with respect to any reasonable degree of scientific certainty.
Correct.
Correct. Now, when you can take that down, when did you first receive the assignment in this case?
I would have to refer to my case record to know the exact date.
Do you have those in front of you?
I do not.
Okay, let me pull up
How convenient.
Oliver 3 for the witness only. And go to the third page. Does that third page help refresh your memory on when you may have received this case?
Yes, on September 12th, 2025.
Okay. Is that when you first started doing work on the case, do you think?
Yes, it is.
Now, prior to doing work on the case, did you receive permission from someone to consume any samples in the case?
Yes, I did.
And could you go to page 15 of those case notes, please? Again, for the witness only. Do you recognize this email?
Yes, I do.
And can you tell me what the email is and what information it conveyed to you in connection with your examination?
Yeah, so it's standard procedure at our laboratory that when we receive a case, we request permission to consume from the agent. We request that they reach out to an attorney if one is assigned. In this case, we will not begin any work on the case until we've received that permission to consume. So this email is us receiving permission to consume the samples and move forward with testing.
Now, does your policy have, does your lab have a policy for preserving samples for independent testing by the defense?
Where possible, we will not consume samples where it's possible.
And that policy is a longstanding one, not only in your lab, but pretty much everywhere in forensic DNA analysis, right?
That's correct.
Goes back to 1996, does it not, when the National NRC recommended a policy that samples be split wherever possible at the front end of the analysis to allow for independent examination.
Where possible, yes, that's correct.
Right. And they did that because it was their conclusion, was it not, that a wrongfully accused person's best insurance against the possibility of being falsely incriminated is the opportunity to have the testing repeated. Such an opportunity should be provided whenever feasible.
Correct.
Okay. Could you now go back to Exhibit 30? Page 8. Were certain DNA samples consumed in your analysis?
Yes, they were.
And for the record, are those listed on page 8 of your report?
Yes, they are.
Which samples were entirely consumed in your analysis?
That would be exhibits 1.4, 1.6, 1.9, 1.10, 1.12, 2.1, 3.1, 4.1, and 5.1.
Okay. Then are there a number of samples listed above there in the report where you say the DNA extracts will be retained? And then you list 1.1, 1.2, 1.3, 1.5, 1.7, 1.8, 1.13, 7.1, and 8.1.
Correct.
Does that mean that those are all swab samples, correct?
They were swabs, yes.
All right. Does that mean, does your report mean that you consume the swabs, but you have some liquid extract remaining as to those samples?
Correct.
Now, are all of the samples, let's talk about the samples in Plaintiff's Exhibit 30. Were all of the samples you looked at there mixed samples?
I refer to my tables in my report.
Sure. Go to page 2, please.
And can we go to page 3 and 4?
3 and 4, please.
With the exception of the known samples from the known individual, that was a single source sample, but otherwise the evidence samples were all mixtures.
And in many cases, they were mixtures of sometimes 4 and 5 people, correct?
Correct.
Now, when you look at mixtures such as the ones in this case, you use terms like major and minor contributor, right?
Correct.
Is that language meant to convey that anything with respect to activity of anybody who might be assigned to that DNA weight? In other words, are you saying the person you label as a major contributor was engaged in any sort of activity? Is there any connection between the use of that language and activity?
None of the testing that I performed could speak to activity or what activity led to the deposition of the DNA.
So nothing in your report, if somebody reads that and says, oh, this one says this person is a major contributor, you're not commenting on anything about the person's activity, correct?
Correct.
And is it true also that there are also several other limitations concerning the language of your report that it's important for courts and people who are reading the report to understand?
I'm sorry, what was the question?
Are there other limitations in addition to the one we just reviewed that it's important to understand about the language you use in your report?
In terms, is there something specific that you're?
Yeah, there is. Could you go to Baker Exhibit 30, page 1, for the witness only? Are you familiar with this publication?
Yes.
This is a publication by the National Institute of Standards and Technology called Forensic DNA Interpretation and Human Factors.
Correct.
This is put together as a guidance document for practitioners on what, to simplify essentially, what to say and what not to say.
I don't know that I would call it a guidance document. NIST is not a regulatory body for DNA testing. It was a report that looked into forensic DNA reporting and specific human factors that could affect our testing. So they may have had recommendations, but as far as them being a regulatory body that's issuing guidelines, I wouldn't state that.
Okay, that's fine. Could you go to 136, please? $136. This is Baker 30. Keep going. There we go, right there. Wait, 135, I'm sorry. And then scroll down to the next page. So they're making recommendations here as to how the report should be worded, correct?
Correct.
Let me ask you whether you agree with some of these limitations, or they call them caveats. They talk about how you describe the number of contributors, and they say the true number of contributors of DNA to an item can never be known. Do you agree with that?
Yes.
Okay. They also say, let me ask one question before I ask this one, which is, do you use something called a reporting cap in all three of your reports?
Yes, so for our likelihood ratio statistics, we cap the statistic at 1 trillion. The actual number Could be a lot higher. It could be quintillion, octillion. We chose a trillion because it has meaning, I think, to people that can understand what a trillion is. An octillion and a quintillion gets a little high at that point, so we cap at 1 trillion.
And they talk here, do they not, about how you convey the idea of a reporting cap? And they say the LR reporting cap was chosen because of the limitation of biostatistical modeling and independence assumptions of STR loci. Do you agree that that's why the cap is chosen?
I believe we chose our cap for the reason I stated.
Do you disagree with that statement in terms of why the cap is chosen?
I'm not familiar with the paper that's referenced there, so I would have to familiarize myself before I said I agreed or disagreed.
Fair enough. And then they also suggest that you alert in your report that profile descriptors cannot be applied to activity level issues. Do you agree with that?
Yes, so this is what you were stating about calling a major contributor. It doesn't speak to the activity that led to the DNA deposition.
Right. DNA profiles may be described as major, minor. However, these descriptors should not be interpreted in the context of a decision regarding the nature or the mechanisms, actions, or timing that led to the deposition of the DNA. You agree with that?
Correct, yes.
All right. And then the other sort of limitation, convey that the DNA results cannot be interpreted as the analyst providing an opinion regarding who the source of the DNA is.
Yes, so this is once again, we don't make source attribution statements. We will say there's support for inclusion, and then we back up that with a statistic.
So from a scientific standpoint, you couldn't read the paragraph that sets out the likelihood ratio in your report, whatever the number, and then blast a headline in the media, Mr. Robinson's DNA is found on this item. That's a source attribution, is it not?
Correct, yes.
And that would not be scientifically defensible, would it?
Correct.
Okay. Another limitation they talk about on likelihood ratios on the next page, please, 137. Likelihood ratios cannot speak to the likelihood of a proposition, only to the probability of the results given a pair of propositions. Do you agree with that?
Yes.
Explain that, because that's a little above my pay grade in terms of understanding.
So a likelihood ratio statistic compares the probability of the DNA profile of the evidence given two competing hypotheses or two competing scenarios. Typically, the first is that the person of interest is included, and then the exclusionary hypothesis would be that the person of interest is excluded. So there's a random, unknown, unrelated individual contributing.
And when they're elaborating on that point, they say a likelihood ratio indicates if and to what extent the DNA analysis results support one proposition over another. It is not possible on this basis alone to determine which is the most probable proposition. Do you agree with that?
Yes.
Okay. And then the next limitation they suggest you convey is that convey the DNA statistics cannot imply uniqueness within a population. Do you agree that that's a legitimate limitation?
Yes.
And explain what that means. Does that go back to the issue of source? You can't assign a source to a DNA sample?
Correct.
Okay. It says you should delineate the meaning of a verbal qualifier, but you didn't use one in this case, right?
Correct.
Okay. Now, you mentioned that your testing cannot, and correct me if I'm wrong, I don't mischaracterize it. Your testing, none of the testing in any of the three reports can answer the question of how and when DNA got deposited. Is that true?
That is true. DNA can't speak to the activity that led to the deposition of the DNA.
And the report says, with regard to that issue, with the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped. Alternatively, a person's DNA may be present when they were not involved in the crime. Do you agree with that?
Yes, once again, I cannot speak to the activity.
Can you explain how it's possible that a DNA profile may be developed even when the contributor of that DNA never touched the item or area that was swapped?
So it's possible if, say, the pen that you're sitting there using for the week, you say hand it off to the judge, and the judge then touches it for a period of time, and then I swab it. It doesn't speak to who handled it last. I could test that. I could get both of your profiles. I wouldn't know which person was the last person to handle that item.
All right. And similarly, if you had a lot of DNA on your hand, we shook hands. I then went to pick up an exhibit, a gun. I touched the trigger of it. Your DNA could be on that trigger, right?
It is possible, yes.
Okay, even though you never touched the gun.
Yes.
And that's why, because of those possibilities, you can't make any assessment of how or when DNA got deposited, correct?
Correct.
How long can DNA persist on an item?
DNA is quite stable over time. It can be broken down due to environmental insults. So things like heat and humidity are known to break down DNA over time. But I couldn't give you an exact number.
Were certain of the samples that you tested in this case degraded samples?
There was degradation present in some of the samples.
And what can cause degradation?
Like I said, there's environmental insults, heat, humidity.
Now, the second report that you wrote had to do with a Dremel item that was taken from Mr. Robinson's home.
Correct.
And did you request certain what are called elimination samples in regard to items that were recovered from his home?
Yes.
Tell the court what an elimination sample is as opposed to a sample that relates to what's called a POI, person of interest.
So an elimination sample is a sample taken from a known individual that it may be assumed that they could have come into contact with it. If I were to say swab your vehicle, then I would want your DNA sample as an elimination to eliminate you in order to look for any additional DNA that may be there.
And you say they're assumed contributors because depending upon the location, for instance, somebody's house, you would expect if there were multiple people in that house that perhaps everybody in the house could contribute to a certain DNA result.
It's possible.
So you'd want samples from all those folks to see if they contributed to an item that would be associated with a place where they congregated.
Correct.
And I noticed from your case file that you also requested, but I don't think you received, elimination samples from agents who were involved in this case.
Correct.
Why do you request those samples?
The type of testing we perform is quite sensitive. And so it is a standard practice that we request elimination samples from any of the investigators involved in order to potentially eliminate them in case they could have contaminated the evidence.
Okay. Now, in report number 157, if you could bring that up, please. Oliver 157, which has been admitted. The elimination samples that you requested in connection with items seized from Mr. Robinson's apartment were from Amber Robinson, Matthew Robinson, and Lance Twiggs, correct?
Correct.
And that's because you had information that those people were associated with the house.
Correct.
And when you tested or compared, first of all, you determined their DNA types, right?
Correct.
Then you compared their types to what you found on the evidence.
Correct.
And for a certain number of those samples, you found the presence of DNA of your elimination samples, not because they were suspects, but because they were associated with the premises, right?
There was support for inclusion of some of these individuals, yes.
Okay, and if you could scroll down to page 4, which is the table, I just want to review briefly with you. For instance, item number 1.4, which was a swab from the rifle. You used the elimination sample of Mr. Robinson's father, and you found his DNA on that particular swab, correct?
I would say there was support for inclusion of Matthew Robinson on the sample obtained from the swabs of the bolt of the rifle.
I'm glad you pointed that out. That's, again, consistent with your other testimony. You're talking again about support for inclusion as a possible contributor.
Correct. And there
Again,
was-
not because he's a suspect, but because he's associated with that premise.
Correct. And there would have been a likelihood ratio statistic calculated and to go along with that.
Okay, could you go to the next page? Similarly, with respect to 1.6, you found, again, Matthew Robinson on swab number 1.6, or a profile that indicated he was a possible contributor.
There was support for inclusion of Matthew Robinson.
Okay. And next page, actually go to page 7. You found support for inclusion of Lance Twiggs on swabs of buttons of a Dremel tool, correct?
Correct.
And going back to what we were talking about before, if a person named Lance Twiggs lived in that residence, came into contact with Tyler Robinson, and then touched a button on a Dremel tool, you'd expect Mr. Robinson and Mr. Twiggs's DNA to be on there, right? Or you could.
It's reasonable to assume that anyone living in the household could have contributed to DNA on an object found in that household.
And similarly, you found profiles to suggest support for inclusion of Mr. Twiggs on other areas of the Dremel tool, correct?
Correct.
Okay. Now, the last area I want to ask you about is, you're familiar with something called NGS?
Yes.
What is NGS?
NGS stands for next generation sequencing. It's a DNA technique that sequences your DNA. So it looks at the individual sequence of your DNA.
And is it true that in your field, that whole area of NGS is something that's at the forefront of everybody's attention? For instance, when you go to seminars and you look at the presentations, there's a lot of talk about NGS, right?
That's correct. Yes, it's a newer technique.
And is it being developed by ATF as a technique that's going to be used or has been used?
Not at this time, no.
And is there plans to do that?
Not at this time, no.
Okay. Do you know if other labs have implemented it?
I believe there may be some laboratories in the United States that have it in use, but I wouldn't have direct knowledge of that.
Now, you used a program in this case called STR Mix, correct?
Correct.
And that's sold by a company in New Zealand, that software?
Correct.
Have they developed another program called STR Mix NGS?
I'm not aware of NGS software.
Could you go to 156, Oliver 156? Let me know when you're there. Are you aware that STR, the developers are selling a product called STR Mix NGS?
I was not aware, no.
Okay. Now, sequencing analysis is different than what you did in this case, correct?
Correct.
And how so?
As I said, sequencing is looking at the individual sequence, the individual bases that make up your DNA, as opposed to the testing that I'm performing, which is looking at length variations. So STR testing, which is the testing I perform, looks at areas of the DNA that are known to be highly variable between individuals. And there are areas where the DNA sequence repeats itself over and over again. And depending on who you are as an individual, you may have a different number of repeats present at that location. So the testing we're performing is looking at those length variations. There's a distinction between, say, if you have 10 repeats versus 12 repeats.
But you're not looking within those lengths to see what the sequence of the DNA is.
Correct.
And that's what this new technology is designed to look at.
Correct.
And the reason it's designed to look at that is because it's been found that there are DNA areas that are different in sequence, even though they're the same length. Is that true?
I think the reason for developing NGS software is to add another tool to a forensic biologist tool belt.
Okay. Now, could you go to 154, please, for the witness only? You're familiar with this chart?
Yes.
Okay, this lists all the alleles that you found for all the testing in your 3 analysis, correct?
No, it looks like,
No, you were right, 154. Yeah, this is one. What's the exhibit on this? Okay. You're familiar with this chart, right?
I reviewed the first page of this chart. I have
Sure.
not reviewed the entire
Go to
thing.
the first page. This lists the alleles that you found, correct?
For the known samples, yes.
Okay, now go to the second page. And is it true that for the alleles of interest in this case, one of the alleles of interest is at the D3 location, allele 17?
One of the locations that we look at on the DNA strand is called D3. That's a location, yes.
Right, and in this case, the 17 allele is important because Mr. Robinson had a 17 allele, correct?
Correct.
And some of the evidence had a 17 allele
Correct.
at that location.
Correct.
So as I understand the way you do this, you look and compare whether those are the same number, basically.
I wouldn't state that's how we do our comparison. So it's not just number matching. We're using STR Mix, the STAR Mix software, in order to perform an analysis of the software that looks at the possibilities for a DNA profile and make comparison to the knowns that way. We aren't using a chart and just doing number matching.
Yeah, and I wasn't suggesting you did, but you're looking at the alleles and measuring the peaks, and it's a fairly sophisticated process, correct?
Correct.
But the bottom line is you're comparing alleles one against another.
Correct.
So if a person is a 1717 and the evidence sample is a 1717, you're looking at that comparison.
Correct.
And again, measuring only length.
Correct.
But it's true, is it not, that researchers have found that that particular allele, the D317 allele, that there are actually 3 different 17s, 17A, 17B, 17C.
Yeah, so there's something known as isoalleles. What that is you may have, in this case, a 17 allele, but the sequence within that 17 allele is different. So 2 people may have a 17, but they may have a different sequence within their 17 allele.
And it's been found that there is a 17A, a 17B, and a 17C, correct?
Objection. Relevance to the probable cause hearing. At this point, I think we've once again gone beyond probable cause, and based on Mr. Grunlander's argument, I would invoke his argument here in the case law that he referenced, and I object to this question.
Let me withdraw the question, reframe it, and move beyond it.
All right, so I'll sustain the objection. It will be reframed and we'll go from there.
This happened a
It's true,
lot
is it not?
yesterday. It happened a lot.
At least 1, 2, 3, 5 of
Fun,
the
fun,
locations
fun.
of interest in this case. Researchers have found that the alleles that you were looking at, these isoalleles, have different sequences but the same length.
Objection. Relevance. The witness has testified she does not do sequencing analysis here, and that's what the question is asking, is about sequencing analysis.
Counsel?
The point, though, is that her testing cannot distinguish between these isoalleles, and therefore it goes to the weight of the comparisons.
But if she didn't do that,
Yeah, that's the point, is that she didn't do it, and therefore she's not in a position to draw conclusions.
Mr. McBride?
That proffer is inaccurate, that she's not able to draw conclusions because she did not do NGS or sequencing analysis. She has testified that her lab and the analysis she did here is not sequencing analysis, it's something different. Whether or not she could do sequencing analysis is irrelevant to the analysis that she did do. If Mr. Burt wants to call an expert to say sequencing analysis is better or something like that, that's fine. But this expert does not do sequencing analysis. Therefore, the line of questioning that goes into sequencing analysis is irrelevant to her testimony.
Let me see if I could lay a further foundation.
All right, so I'm going to sustain the objection. And the question may be re-asked if counsel chooses.
When you do your analysis using length only, do you go by the rule that if any STR locus fails to match when comparing the genotypes between two or more samples, then the comparison of profiles between the question and reference sample is usually declared a non-match, regardless of how many other loci match?
No, it's not quite that simple. What you're speaking of is an exclusion, is that correct?
Yeah, right.
So it's possible for DNA evidence we spoke about, it's possible that DNA evidence be degraded. In a case like that, there may be the potential that some of the profile has what we call dropped out. So it's not present. In that case, we wouldn't expect necessarily to have a inclusion or exclusion at that location because there's no information present there. So it's not quite as simple as is every allele in this chart present in the evidence. There's more to it than that.
If you had a difference in sequence between a known and a question across many loci, would you exclude the person?
It depends.
Again, objection, Your Honor. We're going back into sequencing, which is not the analysis that was done in this case.
Mr. Burt?
Again, Your Honor, if there could be an exclusion based on this and the testing was not done, I think that is relevant.
But as it relates to this witness and her firsthand knowledge, I'm not seeing that tie-in as it relates to her.
All right, let me move on then.
So I'll sustain the objection.
Now, you said that all the samples you looked at in that one report were mixtures, correct?
Correct.
And the number you get in the likelihood ratio depends on how many contributors you estimate, right? The number is going to vary if you say I think it's a mixture of 2 people versus I think it's a mixture of 5 people.
It's not necessarily the number of contributors. The likelihood ratio speaks to the weight of the evidence. And so it's comparing known individuals to the unknown sample. It could be a low number and be a single source sample. It could be a high number and be a 4-person mixture. It's not necessarily directly correlated with the number of contributors.
Let me ask you if you agree with this. This is from the NIST mixture study. An likelihood ratio numeric value is not a measurement of a physical quantity. Do you agree with that?
Correct.
Rather, it is a ratio of probabilities in the opinion of the expert assessing the likelihood ratio and is dependent on the specific propositions used to formulate it and also on the individual making the assessment.
Correct. Yes, I agree.
And does the final likelihood ratio depend on the number of contributors you assume?
No, it does not.
It has no effect whatsoever.
It can have an effect. It's possible. It's possible multiple other factors could contribute to the likelihood ratio.
Is it somehow difficult to figure out how many contributors there are in a sample?
I guess I would say that I use my my training, education, and experience in order to determine the number of contributors present in a profile.
Well, I noticed throughout your report, you use the phrase, for instance, with regard to the 1.2 sample, the profile consistent with at least five contributors, at least one of which is male. And for 1.1, you say the profile is consistent with at least 4 contributors. I assume by the word at least, you're signaling that it could be more.
Correct.
And as the number of people to a mixture increases, the difficulty in sorting out that mixture increases as well, correct?
Correct.
I noticed in your standard operating procedure, there's some guidance on interpreting 3-person mixtures. Familiar with that, right?
Yes.
And it says, and correct me if I'm wrong, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
It's possible for them to present. Yes.
Well, it doesn't say it's possible. It says, for example, approximately in all cases, assuming a mixture as a result of the combination of 3 people must be done with caution. For example, approximately 70% of 4-person mixtures present as 2 or 3-person mixtures based solely on number of alleles present.
You said you're referencing my SOP?
Yes.
Is it possible for me to take a look at it?
Sure.
Your Honor, I'm going to object at this point. The point that defense counsel is getting at is made in the last answer, which is that the difficulty of sorting out mixtures increases as the number of contributors increases. That's all understood, but that has nothing to do with the probable cause determination. Even if it's difficult, the inferences and the evidence is weighed in favor of the state. The court cannot weigh the difficulty in determining this evidence. Is it fair for a trier of fact at a jury? Sure it is. But we're now getting into weight issues that are relevant for a jury, but not for this court.
Well, he's implying there's going to be an extended discussion. I have one question which he wants to look at her manual to make sure it's in there. So, and then I'm done.
All right, I'll allow this question, so I'll
Thank you.
overrule the objection. She may review the material and
So could you bring up
question can be rephrased.
one, exhibit Oliver 148? This is your SOP document, correct?
Correct.
And then go to page 83. Did I read that correctly?
Yes.
And so it's true, is it not, that approximately 70% of 4-person mixtures present as 2 or 3-person mixtures?
It's possible.
Thank you. That's all I have.
Thank you. We've been going for a bit, and depending on how much cross, I'm trying to decide if a break is warranted or if Mr. McBride, you wish your cross is limited. Again, not trying to say which way you should go. I'm just trying to weigh I think we should take a break.
I will probably be, I'll probably be 20 minutes.
All right, let's just keep going, and then at that point, we can take a break. Thank you, Mr.
It's got to be brutal on the judge, huh? Just taking in all this info and it's like, God, I just want a break. Let's smoke a joint. Take a
I
dab.
fucking wish. I wish this dude would fucking take a dab, bro.
You're gonna
Sorry
take a
for cursing.
dab.
Sorry for cursing. I'm from Boston. I curse a lot.
You're good.
But yeah, that'd be nice. Maybe there'd be
He
more
needs, like, he
justice
needs-
in the justice system if these dudes smoke some weed.
For real. Maybe
Just
he should
saying.
get a smokeless dab vaporizer of some sort.
Good morning.
Morning.
Is your lab accredited?
Yes, it is.
What does that mean?
So our laboratory goes through a voluntary accreditation process where a external third party comes in and audits our laboratory to a set of standards. Specifically, the ATF laboratory is accredited, and specifically the DNA section of the ATF laboratory is accredited to 2 sets of standards. One is an international set of standards called ISO 17025 for testing laboratories. And additionally, a DNA-specific set of standards put forth by the FBI.
Does the accreditation require that the methodologies you use be validated?
Yes.
The methodologies used in this case have been accepted by courts across the country, correct?
Correct.
Does the accreditation require that forensic biologists like yourself satisfy certain qualification standards?
Yes, we're required to perform competency testing prior to participating in casework. And additionally, we participate in twice a year proficiency testing.
And do you satisfy the competency and qualification standards required by accreditation?
Yes.
And at the time you did the testing in this case, did you satisfy those standards?
Yes.
Moving to your opinions, where on the firearm did you find evidentiary support for the inclusion of Tyler Robinson?
There were several locations. I'd have to refer to my report.
Okay, would you look at your report? And this is, it looks like report number or exhibit number 30. We can pull that up just for the witness. Thank you, Kimberly. We had it for a minute here, a minute ago. Okay, if we could go to page number 2, please. Will you just list off the areas of that firearm where there was support for evidentiary support for inclusion of Tyler Robinson?
The swabs of the stock and grips of rifle, the swabs of the butt plate of rifle, swabs of the trigger and trigger guard of rifle with possible ridge detail / smudging, the swabs of the bolt of the rifle with possible ridge detail / smudging, and the swabs of the forend of the rifle.
We go to page 3.
Swabs of the barrel of the rifle with possible ridge detail / smudging, the swabs of possible ridge detail / smudging on the optical accessory.
And page 4.
The swabs of the protected underside of the receiver of the rifle after disassembly. The swabs of one 30-06 cartridge case. The swabs of one 30-06 cartridge. And the swabs of one 30-06 cartridge.
I want to ask you about a couple of those conclusions. Let's look at page 5, please. And calculation number 3, exhibit 1.3, do you know where that swab was taken from?
I'd have to refer back to page 2.
Can we refer back to page 2, please, Kimberly? Thank you.
1.3 is the swabs of the trigger and trigger guard of the rifle.
All right, going back to page 5. And we've had some talk, some testimony from you and some questions for you about the likelihood ratios. What was your conclusion as to the likelihood ratio that you analyzed in this question in calculation number 3?
For this exhibit, the DNA profile was at least 1 trillion times more likely if it originated from Tyler Robinson as the major component and 3 unknown unrelated individuals than if it originated from 4 unrelated individuals.
You say at least 1 trillion times more likely. So it could be a much higher number than 1 trillion. Is that accurate?
It's possible.
But the protocols in your laboratory say you cap that at the number 1 trillion. Is that right?
Correct. We would not report a number higher than 1 trillion.
And it looks like you also did a probability statistic as well in paragraph E. Is that right?
Correct. It's another way of stating the likelihood ratio statistic.
And will you state your findings you made here in paragraph E, and that's on page 6.
The probability of an unrelated individual in the population who has not contributed DNA to the sample yielding this level of support is less than 1 in a trillion.
And same question there. The trillion number, it could be far less than that, but you stop your calculations of the statistics at 1 trillion. Is that right?
Correct.
Let us move to page 7 with regard to statistical analysis calculation number 7. Now, do you remember what 1.3 or 1.13 and 2.1 are?
I'd have to refer back to page 3, I believe.
You could jump to page 3. Thank you, Kimberly.
Page 4, sorry.
Page 4.
The 1.13 is the swabs of the protected underside of the receiver of the rifle after disassembly. And 2.1 is the swabs of 1 30-06 cartridge case.
Now, did you do the swabs themselves?
I did not.
And 2.1 is a cartridge case. Is that right?
Correct.
And what's the difference between a cartridge case and a cartridge?
The cartridge is unfired. Cartridge case has been fired.
Right. Let's jump back to page 7. And what was your conclusion with regard to, well, first of all, why do you group these two together, exhibits 1.13 and 2.1 in your conclusions here?
They were both mixtures of 2 individuals, and they both yielded a likelihood ratio of the same magnitude, so they can be grouped together.
Okay. It's not that they were tested together?
Correct.
It's just that the results were of the same magnitude, so they were reported together. Is that right?
Correct.
All right. What was your conclusion as it relates to both of these as to the likelihood ratio?
The DNA profiles are at least 1 trillion times more likely if they originated from Tyler Robinson as the major contributor and an unknown unrelated individual than if they originated from 2 unknown unrelated individuals.
And did you make a conclusion here as well about the a probability statistic?
Yes, so the probability of an unrelated individual in the population who has not contributed DNA to these samples yielding this level of support, so meaning yielding this likelihood ratio, is less than 1 in a trillion.
Nothing else.
Mr. Burt.
The 1.3 sample, is described as swabs of trigger and trigger guard, right?
Correct.
You didn't do the swabs, but am I correct that you have no way of knowing which part was from the trigger and which part was from the trigger guard?
Correct. So they were swabbed together. So I wouldn't be able to say where the DNA came from.
And that's one of the samples that was degraded, correct?
There were signs of degradation present in that sample, yes.
And you said with regard to that sample, that that was a sample consistent with at least 4 contributors, right?
Correct.
And did what you term the major profile have the largest amount of degradation in that sample?
There was, yes.
And you can't tell us anything about when the DNA was deposited on the trigger guard or the trigger, correct?
Correct.
You can't tell us anything about whether, when you say it's at least 4, it could be 5, 6, or 7 people with DNA on that trigger or trigger guard, correct?
Correct, which is why we have the major contributor that is suitable for comparison, and the minor contributor is not suitable for comparison due to that complexity.
And again, major, minor just has to do with the levels of DNA you were seeing, has nothing to do with someone being engaged in activity that is major in relation to the minor contributor.
Yes, so the major contributor is the majority of the DNA contributed to that sample.
Okay. And some of these samples, you have major contributors of more than one person, right?
Correct.
So for sample 1.1, swabs of stock, you have 2 major profiles, and there are at least 4 contributors on that sample, right?
Can I refer to my report?
Sure. It's Exhibit 30. Plaintiff's 30. Right?
You said Exhibit 1.1?
Yes.
Yes, it was a mixture of 4 individuals. There were 2 major contributors.
Okay. And again, with regard to all these samples, no way of knowing when or how the DNA got on those samples, correct?
Correct.
You referenced another statistic in your report, which is the statistic related to paragraph E, I guess.
Correct.
Is it what's called a random match probability statistic? Or is that something else?
It itself is not a random match probability statistic. It is a way to represent the likelihood ratio similar to a random match probability.
But it's still a likelihood ratio computation, right?
Correct. It's based off the likelihood ratio computation.
And it's still subject to all the limitations we've talked about.
Correct.
Can't attribute it to any person. Can't state it's infallible. Can't state there's a 0 error rate. And you can't state that it is a source connected with any one person, correct?
Right. So part of not being able to state source attribution is the reason we report the likelihood ratio statistic. It speaks to the weight of the evidence. And so yes, we can't do a source attribution, and we report that statistic and address that uncertainty that way.
And address the uncertainty along with the other limitations we talked about.
Correct.
Thank you. That's all I have.
Thank you. Anything further for this witness?
No.
All right. May this witness be excused. All right. Thank you, ma'am. You may step down. Anything further from the defense?
No, we have no further witnesses.
All right. Returning to prosecution, anything further?
No, Judge, we have no rebuttal evidence to present at this hearing. The state has no rebuttal evidence to present at this hearing. However, before we break, there is the matter that was discussed yesterday with respect to publishing in the courtroom Exhibit 12.1, so that the victim's family can observe that.
Thank you. All right, do the parties wish to be heard as it relates to this briefly, and then the court will issue its ruling. And
Your Honor, I actually just want to make a quick record. We have advised Mr. Robinson of his right to testify at this hearing, and he is choosing to take our advice and not testify.
is that correct, Mr. Robinson? And I note that he's nodding in the affirmative. Thank you, Ms. Visser. All right, in regards to the outstanding issue about the publication of State's Exhibit 12.1 to the courtroom only, to persons here, any further input from any of the parties before the court issues its ruling?
Jeff Neiman on behalf of the victim. My understanding is you ruled yesterday that you were going to play it, that you did grant our request. So I don't know if we.
Thank you.
Judge, I might simply add, given the court's ruling this morning with respect to displaying exhibits, we may want to make a record with the live streaming folks here that it's not going to be published.
Thank you. All right, nothing further from any of the parties? Okay. Just updating some notes. All right. The court wishes to readdress yesterday's ruling in light of this morning's sanction as it relates to Exhibit 16. The court separately addressed that incident and imposed a sanction on the record. Having considered all applicable public access, fair trial, privacy, and victims' rights interests, the court adheres to its prior ruling. The court finds that temporarily limiting live stream to audio only while Exhibit 12.1 is displayed is necessary to prevent the inadvertent publication of the exhibit from being transmitted to outside the courtroom, and no broader and is taking the least restrictive means to accomplish what is being requested. Accordingly, Exhibit 12.1 may be viewed by all persons physically present in the courtroom, including victim representative Ms. Kirk in her capacity as the victim representative. The same in-court viewing rules applies to all parties and courtroom attendees. And that is the ruling of the court. Let's go ahead and proceed to that, to the state. So could the camera operator let me know when we're switched to an audio only? We are? Okay. All right, and as it's switched to audio only to the state, now my understanding there's no audio on this surveillance on 12.1, is that correct? All right. All right, so let's go ahead and play that. And I'm going to rule that this also applies to the still photographer. It cannot be captured the screen in any way. I noted video recording, but I intend as well as no still capture of
Trying
any
to
of the
save their
monitors
ass
during
after
the
all these
publication of
bungled,
all right.
just bungling that shit, this stuff.
And to the state, just let me know if you're ready. Let's go ahead and play it now. Audio.
I am putting together a clip right now. I think I got what I needed. So, audio only of the evidence, no footage whatsoever of the evidence. That's kind of where we are right now. I'm editing a video, a couple. I've been putting out videos as we go. What do you think so far, bro? You're on mute. Yeah.
Well, I mean, at the end of the day, this is a show trial. This is
hearing, yeah.
Whatever. Show hearing. This is a nothing burger.
Yeah.
You know? That's what it feels like to me.
Yeah, and we are kind of experiencing that, obviously. This, for people that don't know, this is literally to show probable cause. We talked about this morning.
Yep.
On the pre-hearing before the show started, before the hearing started. And that's what it is. The thing is, the reason why I said earlier the judge is going through all this stuff from all this week, well, they keep going further into what you would present at trial. And he's like, I'm over that. It looks like.
Yeah, my question is actually the same question to you, because, you know, every day I may catch like, you know, Valhalla's like update or Ian's update, right? Like I'll catch that stuff because I don't have 8 hours in a day to watch this, but you actually have watched seemingly every minute of this trial. So I think there's more substance in me asking you what you think.
1 second and I'll tell you. I mean, I'm just uploading this post real quick.
Yeah.
Tyler Robinson will not testify on the record.
Yeah, I would highly doubt that he would in a preliminary hearing.
Yeah.
That you typically don't do. In fact, especially in like murder trials, they will always urge you to not testify in your own trial.
Right. That's very common. Yeah, it's very
it's very common. And then look at like another high profile murder trial, last year, 2 years ago, the Murdaugh trials, the guy who like killed his entire family basically, except for one of his kids. And
brutal.
And then he went and testified. And it was like, I followed that so deeply and watched all the documentaries and everything. And I was like super on the fence of whether or not he did it. And then he went and testified. And I was like, oh, he did that shit. And everybody else was, and now he's in fucking prison forever. Sorry for cursing.
So
you know what
for
I mean?
him, you're saying, no, he testified and then he ended up in prison.
Yeah, he testified, and my like if I were on the jury, I would have been like, oh yeah, this dude, because like the thing is like you could be really nervous and like fumble over your words, and then that could be enough to be like, whoa, wait a second, I don't know if I trust this guy now.
Yeah.
So yeah, so I don't know. I don't
Yeah, I
think he's
think
gonna-
it's definitely have thrown these two clips together. Yeah, I mean, I think that it's a double-edged sword. You start testifying, and things come out that people don't need to know or don't need to think about, or because right now, without testifying, they only hear and see what they hear and see from you sitting there, your facial reactions. You know, the jury is not there, but the judge and stuff like that, and also the audio from video footage, the live stream footage. But once you put him up there, and if he's got a certain type of voice that people don't like, or if he slouches his shoulders a certain way, it all turns into a big fat scary situation.
I think if you were in that position, you want the professionals who do this, who defend people for a living, you want them to defend you, and you don't want to undo months or years of work because like you're not good on camera, you're not good on a microphone. Like,
100%.
do we even have, like, has anybody even seen, like, I don't even know if I've ever seen a video of this kid talking.
That's
Like,
one thing we haven't
like
seen
ever. Right? He's clearly like wasn't like eternally online, you know. So I think that use that to your advantage and let the lawyers do their job and let the evidence work in your favor. You know, if you're truly innocent. If you're truly innocent. Now, if you're super charismatic and all that, maybe there would be a way to, you know, to come out and be like, you know what, I'm gonna come out here, I'm gonna sweet talk everybody, and how could I mean, come on, me, I'm innocent, dog, you know, like, but I don't know.
Yeah, that's what you would think. You would think like, oh, I should. Whoa, I almost knocked my camera. I'm trying to figure out what the best way to have my microphone is. If it was up here and it sounded fine, I would probably rock with that. But then it puts a shadow. How's that sound? Sounds okay, or it sounds further away?
It sounds further away.
Yeah, that's what I feel.
But you know, yeah, I actually went from having my mic on a boom arm, and now I got this, and I'm sneaking it down, trying to sneak like under the camera a bit, and that's working for me. No, I was also having issues.
I have mine like that too, where I can kind of come like this, but it gets in the way of my hands.
The auto focusing kept like focusing on my microphone and not me, and then like blurring me out. So like I started doing this, and it fixed the issue for me.
That makes sense. Yeah, this might be okay. We'll see how it goes. But yeah, so you asked me how since I've been covering and watching everything, I don't see mountains of evidence. That's what they promised us. I don't see it. It's not that I don't see it, it's just that it's not there. There's mountains of stuff, but evidence or probable cause, there's not yet been any actual metadata, GPS coordinates, anything to make us believe that he's there. You've got grainy footage. You've got footage of bald, like the person that gave you the footage of the Challenger, Dodge Challenger, told you that somebody was a bald driving it with 3 other people in the car.
Yeah.
Why didn't this information come out until now? You had Barron scraping the internet for weeks looking for this charger on every map service he could possibly find. And so there's a lot of hiding the ball that I don't like. I don't like it because we should all be here on the same team together, whether you're in Charlie Kirk camp or you're in not that. Whether you're in the Fed slop camp or not, you should be looking for truth. Honestly,
that is the equalizer, right?
Yeah.
The equalizer is you should care about the truth, and if you don't, then that means that you're suspicious.
Yeah,
straight up.
Straight up. That, I don't understand. You know, let me read a couple supers, and then I want to check out Webb as well because I definitely downloaded it. Thank you, Helga. I have your video, so I might evidence being presented to courtroom only. Wow, this is actually going on their video. I guess I'll just. Oh, he's talking.
Transmission may resume. Just let me know when.
Wow, that was fast.
Live.
Oh, wow.
All right, thank you. Does either party need the benefit of the record?
The state does not, Judge.
No, Your Honor.
All right. So this preliminary hearing is continued to September 1st at 10 a.m. for an in-person hearing. The court will allocate up to 4 hours total for argument. That's encompassing both parties. Does the defense request that Mr. Robinson be physically present for that hearing?
Yes, Your Honor.
All right, we'll make the recording. Thank you. The court appreciates the professionalism, civility, and respect shown by counsel, the parties, and all persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
All right. Wait, so that's it? This is the end?
At 10, persons in attendance throughout these proceedings. As there are no further matters before the court, this proceeding is adjourned until September 1st at 10 a.m. Good afternoon to you all.
That's it, bro.
That's it.
That's it.
We got a little quickie half day. Okay.
Yeah, I guess that's it. Wow.
Yeah.
So yeah, matters that were covered today. So few things I guess we could run through. I've been posting stuff as well. Tyler Robinson will not be testifying, at least in preliminary trial hearing, which is very common. The judge goes audio only on footage or evidence that is presented. And I think that they're setting that standard for the trial. This isn't for prelim anymore. It's over.
It's over, yeah.
They saved that for the last day. And they probably knew they were going to end up doing that anyways. And I am suspicious of the fact that they may have done the leaking on purpose. So,
of course. Of course.
That could always be the case. What else? I think I took some notes here as well. Reserves this sanction for everything as it relates to September 1st. Court won't issue a pre-ruling when that request has been filed. All the motions, yep. So he's just going through. All right, so let's check out some of the super chats, and then we're going to do some web activity for a bit. So if you want to stick around, feel free if you have any questions for us. Amy, will you look up what a voir dire is? Yeah, so voir dire is, I put it on the screen earlier. Voir dire is essentially the selection of jury. That's what voir dire is. Let me see if I can find a voir dire definition. Let's take a look here. So I could probably just go like this. Voir dire definition is jury selection. It is the jury selection process where attorneys and judges question prospective jurors to uncover their biases, conflicts of interest, or preconceived notions. So that is the going through and figuring out, are these people going to be good for the trial? So if you've ever seen what a jury trial looks like, and when they're selecting jury for jury trial, it's a whole process. It's a whole process. So that is called voir dire, that process. Kilroy, Jenks, thanks, and others there. Happy Friday. Thank you for the coverage and commentary. You're welcome. Thank you for being here. Thank you for the super chat. Philippe, Mr. McCurley looks terrified. Is Kevin a human?
I swear. I'm a human. I'm not AI. If you don't know, that's how you
Draw
tell.
the fingers.
You do 3 fingers in front of the face and you'll see artifacting and trailing and all that stuff, but you don't, because I'm real.
So if we can build one that can imitate that, then we'd be able to change the game.
Yeah, I would never put that into the world.
Butterfly, hey, what's up? Still praying for you. $9.99. Unfortunately, I think the cameras will be removed because they don't want to see the lack of mountain of evidence. It will ruin the narrative that Erica is an angelic tissue dispenser.
I don't know about that. I'm going to be honest with you, because this trial, we only get maybe one a year like this. That is huge, that every news organization out there can just pump out content on stream all day, all that. This is a cash cow for the media companies, and they're all kind of losing their shirts right now. And I think that the media companies are going to push for this, and they have power in this country. So I'm not entirely sure that I would discount the idea that they wouldn't make this public.
Yeah, this thing is very concerning that we've gotten this far with so little. And they've had months to kind of paint this narrative.
Mm-hmm.
The narrative painting is it's like one of those paintings that people buy and it looks like shit, but they're like, this is beautiful. I see myself in this. My emotional genealogy is in this, but it's just slop. That's it. Jessica, welcome.
Slop.
Tomorrow we have our members only 10 a.m. Pacific. Come join us. Amy, thanks for holding it down. Amy, $10. Thanks. Do you think they're going to get him with the cell data? Do you think they are going to get him with cell data at trial? I think they might. I hope that they bust out. I want to see the cell data, man. But it's like, I don't know who I trust anymore. I don't know if I trust what they bring out. I don't even believe that this is his phone, to be honest with you. So I was Google searching and I was looking to see what kind of phone is this exactly? What are we dealing with here? I'll bring up the phone again for everyone to see. This phone, it is a very old one, super old, not super duper, but it's so this was interesting. Let me pull up what my Claude said, because I did actually ask it. Here, let me show you what it's very interesting what Claude said. Join ClubVatra.com if you want to come hang with us in the private community. We do have sessions weekly where we all get to have a say. Come join us, ClubVatra.com/DangsterIntel. So let me show you what Claude said regarding this, because it's actually interesting. Okay, so yeah, here it is. Let me close that banner. So it says, I asked it, I said, what cell phone is this? What iPhone gen does this look like to you? And I gave it this image. From
Looks like an Android phone of some sort.
Yeah, it does, right?
Some old busted one.
Says the tell is it says straight read on the hardware from that image. The tell is the cracked, damaged screen with that vertical green line of dead pixels. That green line failure is a known OLED display defect, which matters because it narrows the field. Apple went OLED across the board, starting with the iPhone 12 line. The 11 and SE still used LCD, which fails differently. Usually black blotches or backlight bleed, not a clean green line. So it's saying, I can't say distinguish 13, 14. What phone is it? The question is being used by some accounts to argue that the attacks are fake or planted, that the evidence doesn't match Robinson's known phone. You can't resolve that from a blurry photo of a cracked screen. The phone model isn't the authentication question. The authentication question is whether the forensic extraction, the Cellebrite, which is an Israeli company, brought to you truly by. Here, I'll show you.
Isn't it always?
Yeah, isn't that great? I got this from Baron. Let me pull up my bookmark here. 1 second. So he bookmarked this, or I bookmarked this. Check this out. So he said, hey, Grok, where is Cellebrite headquartered? So if you don't know, Cellebrite is the company that's doing the extraction of the data for the feds and for this case. Are there allegations of where are they headquartered? Where was it founded? Are there allegations Cellebrite can alter phone data rather than just extract it? Tell me about the 2021 security analysis by Signal, Moxie, Marlin, Spike. So then Grok responds, Cellebrite was founded in 1999 in Petah Tikva, Israel, where it is headquartered. Its tools are built for forensic extraction and preservation of data from phones, and devices. There are no established allegations that Celebrite alters data on the phone themselves. In April 21, Moxie Marlinspike published a detailed analysis of Celebrite, UFED, and Physical Analyzer. He identified vulnerabilities allowing arbitrary code execution on the Celebrite machine when scanning a phone containing specially crafted files. These could be used to modify the generated reports, inserting, removing, or altering data across current, past, and future reports without detectable changes to timestamps or checksums. The focus was on weaknesses in Celebrite's own report generation software, not on modifying cell phone data. Celebrite issued patches afterwards. I think he continues, actually. Let me see. Did Signal report find the following? And he goes through, you should go check out this thread if you're on X. He goes, you can just follow it down and see if he continues. But yeah, doing good work, doing the Lord's work. We run through a couple more of these. That's the thing is I don't trust the data. It's like I need to see it. It's really hard. Celebrate if they're doing all that shady stuff. Not good, man. Scary.
Jimmy's calling me. I'll be right back.
Yeah. Don't change strategy when you are winning, says Philippe. But I would want him on that stand. I want to know if he was in on it. Yeah. Oh, you mean Tyler? Yeah. Yeah, but you don't want to have him on stage. You know what I mean? Because even if he wasn't in on it, it could make him look like he is. And that's the issue. Alec Murdoff won an appeal and is now in retrial. Super wild case. I still can't decide if he did it or not. Yeah, I got to look deeper into that. Let me see. Alec Murdoff case. Might be a rabbit hole worth digging down. Thanks for the super, Eric. Good to see you. Trial of Alex Murdaugh. State of California, Richard Alexander was a trial of American former lawyer for the murder of his wife and their 22-year-old son. Oh, that's terrible. Thank you for the 50, Kamalani. Thank you. Wow. Thank you for all you do, Danks. You're welcome. I'm here for it. I appreciate the super chat. Thank you so much. Very kind of you. Keep sticking around. Keep learning. AK written, $5. How would TR testify? Tyler Robinson testify and not implicate those that set him up. Yeah, it would be interesting if he could, if they had something set up for him to be able to like just blow the horn on everybody. Could you imagine? He takes the stand. He's like, this person told me to do that. Here's evidence of the defense and pulls out all this evidence they didn't want to show from the prosecution side. Yeah, I don't know how they would, but 4 hours of arguments on 9/1. What happened to that old-fashioned ass nations? Okay, so what I'm going to do from here is we are going to open up the Webb app.
Before you do that, Jimmy just said that he's got some breaking news that he just posted on X just a few minutes ago, sent it to me. I just DM'd it to you on X if you want to pull it up. But he says it's pretty spicy.
What is it, the Erica Kirk stuff?
It's an Erica Kirk thing. Yeah, it's looking pretty spicy. He said we should break it on stream right now. That's what he told me. So I said, all right.
Breaking. Is Erica Kirk trying to manipulate the judge? This is from Real Bays. If you don't know, at Real Bays. I think I might have showed this earlier.
Bays is Bays.
Sources say when the courts were adjourned yesterday, Erica Kirk made it a point to stand up staring at the judge with her mascara running. I can't say for sure how long she stood there, but I am told it appeared as though she was trying to make an impression on the judge. Erica Kirk has gone viral multiple times for her signature tissues, but yesterday she made it a point to let her mascara run and even left a sealed package of tissues under her seat. I'm also hearing that she was seen wearing a ring with a gold band and an Eastern star. If you're not familiar with the Easter star, is a strongly linked to Freemasonry. After a full week of preliminary hearings, we have been left with more questions than answers. I'll keep doing my best to find the truth about what I'm afraid that there are a lot of very powerful and dangerous people that are going to do what they have to in order to keep whatever really happened that day from getting out. The image of the ring below is not an image of the actual ring, but one that resembles the one she was allegedly wearing. And I know Bays has been talking to people that are at the courthouse.
Yeah. I
But
saw Billy and Brandy are there, so shout out them. I saw that they were camping out at 2:30 this morning, sleeping outside the courthouse so that they could be one of the 2 of the 14 people that are allowed in today. So shout out to them for being on the streets.
yeah, shout out to Bays and shout out to, I talked to Kelly this morning. I talked to Brandy. I text her on IG. So this person says the ring is the Presidential Medal of Freedom ring that Charlie was posthumously awarded on his birthday and or what would have been the start of the 33rd year of his life.
Interesting. 33 hours, 33rd year, Freemasonry.
Let me see if we can find
We'll
that.
see you in Valhalla.
Let's see if we can find that ring.
You know,
images.
There's a lot of 33s out there.
Is that it? This is the star he's talking about?
Yeah, is it a medal and then a ring in there? I can't see. Can you zoom in?
I'm
on
trying
that?
to open it. Hold on. Yeah, here. Oh yeah, there's a smaller one. You see that?
Yeah. There's a smaller, but is that a
Right
ring
here.
to the right?
Well, you can make anything a ring.
Yeah, but that's a
Maybe
bling bling
this.
ring. That'd be big.
So let me see the original one. Where is it? Here. So that and this. It is very similar, no? I mean, I guess it's similar. I don't know if it's the same. Okay. Well, we'll hope to hear more from that.
Yeah.
Interesting.
I mean,
Yeah,
I
he's been
wouldn't put it
posting.
past her. She is a manipulative person.
Seemingly so.
I was gonna curse too, but I didn't.
Go follow Bays. He's been growing,
called
bro.
her-
He's been.
called her
I
a
think he grew
person.
I think he grew 1,000 followers. Okay.
Good for him. Good for him.
Any
He deserves
supers or
it.
anything am I missing here? Yeah, no, he deserves it for sure.
You too, man.
Anne
You
Marie.
guys are crushing it.
We're doing our thing. Anne Marie, $9.99. Celebrate also was in the Karen Reed trial, and the guy from Cell is Ian Whiffen, who said one thing, then flipped his tune on his results on that trial. Celebrite is bull butter. Money makes them lie.
Yeah.
Oof.
Karen
Good
Reed
point,
trial. Another one that was like super on the fence of whether or not she did it, but to me it didn't matter because the cover up is the real story. So, like proof that the police covered it up. Great trial though. And retrial too.
Apparently, Ian Whiffen with Celebrate fell in hot water over his expert testimony. Interesting.
Oh.
Thank you, Ann. Good to see you. Kathy, member for a month, so now Erica can intimidate a judge. WTF. I mean, she can try. You know what I mean? I don't know if she'll imitate any. I don't know if she'll scare anybody. She could
I
try.
don't know if it's I think manipulate would be a better word than intimidate. You know?
Very good. Well
But
said.
yeah.
Well said.
But yeah, no, we're really stoked about Webb. If you don't know, Webb is an AI tool, and yes, I understand people have misgivings about AI, but we made an AI tool that helps with investigations and also will not hallucinate, will not lie to you, because if it makes a statement, it has to back it up with the documents. It just has to. And it doesn't go onto the internet and, gather people's opinions and give them to you. It's facts only, right?
That's how I am. I run facts over feelings,
Facts
receipts
over
over
feelings.
narratives. That's my show.
Exactly. And so that is the same ethos that we have at Webb. We have a lot of different stuff. It started with the Jeffrey Epstein files and all that, and we have all sorts of data sets in there, and it's constantly growing. But this morning, we put in all the Tyler Robinson transcripts and testimonies, everything related to the case that's out right now. Today's transcript will also be in once they release it. Give us like an hour or two, and that will also be in this data set. But you can look into all of the evidence. We even have videos, everything. So you can go in there and you can go back into the last 5 days. You can really comb through it with a fine-tooth comb, because what are we going to do until September 1st, right?
Yeah.
There are a lot of people out there that want to dig through this, right? And I think that this is a great way to do it, because now you can ask questions. Hey, tell me everything about the second bullet. Tell me everything about this. So instead of waiting through 10 hours of testimony, you can get a report really quickly. And so if you haven't tried it, also, because we wanted to sweeten it a little bit, put a little cherry on top. If you have never used Webb, then come in, $5 for your first month, right? We dropped the price significantly so we can get more people in. And I swear to you, if you try this, you start digging into some data sets, I think you're going to want to stick around, because this is a really powerful tool.
Yeah, it looks great. You've got the trial now, Epstein, Judaism, pharmaceutical, litigation? Is that what
Yeah,
that's
yeah.
COVID, 9/11, chemical industry, fossil fuel and climate, Buddhism. This is great. Can people
Thank you,
upload their own and make them public or not yet?
That's out, not public yet. We do not have. The thing is that what we don't want people doing is like data poisoning, right? Which
Yeah.
you probably understand, but basically uploading intentionally or unintentionally bad data. So everything that we release, like, we make sure they're all primary sources.
I think it'd be dope if you had a community like Reddit side with mods
Correct.
that were able to verify, or even AI agents that could verify it. And then
Yeah.
we could have that. But that's a big undertaking. I don't know if
It
that's
is a big undertaking. It's one that we certainly we certainly want.
you thought about it.
We've thought about this. We're thinking of other ways that we can get people to do like joint investigations. Like right now, you can come into the Discord, and we have, for every one of the data sets, basically we have channels, and people go in and they're putting out investigations and people are talking on them. But we want to bring that into the app at some point. It's just, what is the best way to do that? And that will be what we do. But you can and unfortunately it's not in the base tier, but there are higher tiers that allow you to put in your own documents, like thousands of pages of documents. Unfortunately, those are more because OCRing and ragging and all this stuff is not cheap. Getting all of the files into a format in which our system can understand it and operate it and put the context to everything else gets kind of expensive. So the whole thing is honestly very expensive to run. Which is why we unfortunately have to charge so much. But fortunately for our users, the value is there. Some people, this is like constantly every day. It's like, I turn on my computer, this is the first thing I open. So if you are an investigator of any type, or you're just really interested in, coming to your own conclusions, looking at data sets, things of that nature, this is the thing for you. And so, yeah, today we have the Tyler Robinson trial. This is also the new look of our program, which again, we just launched today. So today's a big day for Webb. So I'm stoked to come here and go through it and talk with you guys about it. Super
Congrats.
stoked. Thanks, man. Yeah.
Yeah. I'm trying to think what I would do. Let's see if I open it. So I've never really used Webb fully. I know that we talked about the canvas and stuff like that. So I'm still very much a noob. I did a lot during the Epstein files, but after that, I
Yeah.
haven't really used it. So
Yeah, we
I
actually have
kinda
a new feature as of today. So once you have, you know, let's say you're in a data set like this in the Tyler Robinson, and you have a few chats going, right? Like you say you go on like 5 different topics, right? You have 5 different chats going. Once you hit a certain thing, you can actually auto canvas. So it would actually bring that over, trip over drip. That's what's up. That's my boy Trevor. You can create like the canvas where you put the documents and the videos and all of it and string it together and notes and all that. And now we actually have auto canvassing once you have a certain amount in your canvas in your data set, which is really cool for the people that like maybe can't sit there and like put documents together and string them up. For some people, they love doing that. Ian is one of those people. He will do that all day. His canvases get insane. But to have the auto canvas feature is really awesome. And that's a new feature that we have now. So
very dope.
Hell yeah.
Very dope. So if I wanted to, like, if I were to, can I drop images in here? Or no, it's just text.
Yes, I believe you can drop your own image. Well, so the thing is like if you're going to drop your own images and links and things of that nature, those also need to be kind of like OCR'd and all that, so that those become part of the context that then the answers have. So in the higher tiers, you can.
Okay. But if I were to like drop this, no, that won't work because I was trying to drop that in there.
Yeah.
But I'm on the 20 tier, so
Yeah.
I got you. Okay. So yeah, what I here it says dig deeper. The ATF couldn't match the bullets to Ross's rifle. Prosecutors found DNA on the trigger. Surveillance shows the shooter had a distinct limp before the shooting. What does the defense say about this gait inconsistency? That's a great question.
Yeah. So you could take that and like copy it and paste it, and that be your next inquiry in this chat.
Yeah, I would say, what is the truth about the confession from Tyler Robinson? Did he actually confess, or did he just turn himself in so he didn't get killed? Let's see what we got here. So it searches through the court hearing transcripts. Is that what this is doing? Kevin?
What's that?
It's going through the court hearing transcripts. Is that what
Correct.
it's
doing? Yeah. So it's court hearing transcripts. I actually have let me see here. I actually have a rundown of everything that's in this. Let me see. Maybe I
So it says, and it goes and it shows the documents, the candidate for the documentation, the heart of the question, 2 very different narratives. There are 2 competing stories about what happened when Robinson walked into Washington County Sheriff's Office on the evening of the 11th. Documents contain evidence for both, and the tension between them is central to the case. What the prosecution says is the confession narrative. The charging document is clear, according to the state. Robinson did far more than just surrender. He admitted to the shooting multiple times to multiple people. So that's what the prosecution is, the state is saying. To his father, when Robinson's parents brought him to their home after his father recognized the rifle in news photos. This is so dumb to me. Like the news photos and the Tyler. I just don't know how the father would be able to identify that gun. They're all the same. They all look the same.
Mhm.
That especially the rifle they're trying to get pass off. Implied that Robinson implied that he was a shooter and said he couldn't go to jail and just wanted to end it. When asked why he did it, Robinson explained there's too much evil in the guy, Kirk's. The problem is this information is coming from those text messages.
Mm-hmm.
I think. So this shows the information over here.
Was it the
Yeah,
text
Sanction.
messages where he's like, a police vehicle is following me around, like all like spoken in
Yeah.
like old English type shit.
Yeah. So this exactly, and this is apparently
what 20-something calls a car a vehicle?
Yeah, I don't.
Literally.
Unless you're in the military, or unless you're like my stepdad was in the military for his whole life, and so he always said vehicle, so I say vehicle. But
Yeah.
I don't think any of their family was in the military or police officer. I think that is the only person, the one that turned them in. But yeah, this would be interesting to go down. I definitely will. I got the month for sure, and then hopefully I'll get hooked on it.
Oh, you'll be hooked, bro. You'll be hooked. And then the cool thing too is that what you can do is you can actually merge multiple data sets up to 5 into one canvas. So, like you could say take the 9/11 files and the Epstein files and try to find interesting connections there. Hell, you could even put the Judaism files in there and start asking about Goyim or whatever you want. It's pretty interesting though, where you can take these multiple different official data sets and put them together and then start cross investigating.
So I could, I click pen and then it goes. Oh, I see.
Yeah. So if you put so say you take another one, like hit another one of the red buttons, somewhere.
And Mr. Robinson turned himself
Okay, now
in.
you can pin that. Yes, it cues you right up in the videos, right? Now see where they have like the red dots on each one. So you could see where when a cross comes onto that red dot.
And Mr. Robinson.
Nope. When a cross comes to that red dot. Oh, no. So you can click it when it's a cross on any of the red dots, and then it creates a string, and then you can put a string to the other like red dot somewhere.
I see. Oh, that's pretty dope.
So you can link them together, and that's how you create like a detective board, an investigation board, right?
I
Evidence
like it,
boards. Yeah. And then you could even like highlight like a section of that, and then put like of the wording, and then it puts like a note with it that you could also connect, right? So you can make all of the connections there. So if you're more of a visual person, this is a great way for you to visually look at all of this.
Very nice. Yeah, I like that.
Yeah. And
Dope.
these canvases are basically infinite.
Yeah, I see.
As you can
literally,
see.
Yeah. That's
it's
dope.
Basically infinite. So
Wow. Yeah, I could definitely get lost in that for sure.
yeah, and of course, we made this to be stream friendly, as you're seeing right here. This is made in collaboration with Ian Carroll. He's one of the owners of the company. This is largely his baby, his idea. Yeah, you can do do all that sort of stuff. It's fun.
I am a human.
Yeah, that's right. But yeah, no, so this, like I said, is very much comes from Ian, who does live streaming, who does content for a living, investigations for a living. And so so this is made for streamers to use, for investigators to use. And we urge more streamers who do use this to use it on stream, not just to like promote us or anything, but because these visual aspects can help you, convey what it is that you're trying to show with evidence and the visual aspect of the evidence. So this is a really great tool. And people have been asking for Tyler Robinson stuff. There's not much that's official until now. But now through this preliminary trial, now we actually have real things. We have the charging documents. all the state's evidence, obviously the transcripts of what was said, what was shown, and all of that. And so there's actually like quite a lot of information here. So if you're interested in this trial, especially between now and September 1st, well, this is a great research tool for you. And then obviously as more things come out, more transcripts once September 1st happens, however the trial goes, we will keep up with that. We will constantly be doing this. So not only do you have to rely on the daily, videos from your favorite creators like Danks that tell you what's going on, which you should still watch. Now, when, he's trying to condense, 8 hours into 15 minutes and he tells you about something that happens, you're like, wow, I want to dig into that more deeply. Now you can with Webb, and you can really get into it. So yeah, very, very excited about this. We're very proud of this, honestly. And we hope that more people get in there and take advantage of this $5 for the first month offer.
You need a promo code for your peoples, man.
Yeah, we're working on that. You got to remember, we're 4 people that run 2 businesses. We have the buyer app, and then we have this.
I hear you. I know.
And we're just a few people. You know what it is, man. So,
I'm one person running 2 or 3. I don't know. You can count it as 40 if you really want it.
Probably,
But
right?
truthfully, I mean, I'm the only one running ClubVatra. I built it. I'm marketing it. I'm running the socials, running the back end with all the emails and Stripe and payments and freaking.
Exactly.
But that's part of
it's a
it.
lot.
Jesse is the front face, and we're still building, so it's not even time for him to really go hard yet anyways. But it's working as baseline intended. But there's so much. I'm over here on this other computer building some other stuff for it, working on the analytics dashboard, building out the two-way messaging system. So there's a lot. It's busy. It's not easy, small. But that's how you got to make. If you don't want to give up equity in your company, because believe me, people do see value and they want to pay, but you just got to stay away from all that. If it's slower, it's fine. It's better to do it on your own.
Yeah, for both of our apps, the only owners are the operators. We've never taken money from anybody. We do not launder influence to anybody for anything. And so when you're, supporting us by like getting a subscription or whatever, you're actually like supporting like real people, like a small group of people who are like actually trying to like make a difference and who are trying to keep like, I mean, we get all sorts of accusations, right? Like people think like we're like, selling the information and, like we're taking information of who the dissidents are. It's like, no, we're like literally just trying to give information to people. We build tools to put information in people's hands so that they can like actually move through the world accordingly. And that's what it's all about. But
there's actually like a bunch of laws around that shit. Like people don't even know. You can't just take data from like Google and then do whatever you want with it. There are laws against that, and there's strict laws around it.
Exactly. It like even to the effect where like, people like ask us every day, like, put like WikiLeaks, like get all the WikiLeaks in here because we want to be able to like go into WikiLeaks, but like ask it with Webb and stuff like that. And it's like, while we would love to do that, the reality is the laws prevent us from doing that because most of that material is hacked material. And if we, say publish hacked material, we can get sued and our entire business can get absolutely steamrolled because we are sending out there publishing hacked material. Like you can't do it. So this is literally like why like Julian Assange had been in hiding in Argentina or wherever the hell he was for the last 15 years, right? Someone said our personal data is fair game. We do not get anybody's personal data. We only We only gather the data that we like absolutely have to, either by law or just so that like you can have an account. Like we have to have your
Log in.
email so you can like log in, right? Like
Yeah,
all
they
that
don't
sort
store
of
your
stuff.
password or anything like that.
No.
They're
And-
using you're using basic email. You're not using OAuth or anything like that.
That's a dev question. I'm not that technically savvy, but I will tell you this too: we are SOC 2 compliant, which basically means that we are compliant in a way that protects everybody's information. But like our whole thing is that we are not into like data mining and data sales on either Webb or Buyer. That is like a very like from the top, one of the first things we've ever talked about doing was like never selling data, which means like we will like we're not going to leverage you guys so that we can make a couple of bucks. That doesn't work for us at all, because we don't want people doing that to us. And we want to show that it can be done. We want to show that you can have a successful app without having angel investors and without having selling data to all the big companies out there.
For sure.
Yeah, it's just
And that's what we do
it can be done.
too. And it's
Exactly.
in our terms, like if I go to let's see, terms, it's either terms or policies. But in here, I put everything out and I explain all the security. I don't know if it's on terms or policy, but everything I put in here is legally binding. Like I have to follow this. If not, I will lose the ability. Let me see, is it policies? I'm not sure. It's terms and something else, but maybe just terms. But yeah, no. But I did want to show, because Amy asked. So that, first of all, that's Webb, right? You want to make sure, if you don't know it, I'm sure most of you do. That's Webb. What ClubVatra, Amy, you were asking, can I join something where I can talk? Yeah, you can talk in all of them, because this is just a way to get into the Discord. And in Discord, all tiers can talk. You can go in. If you've never seen Discord, I don't mind showing you.
Yeah.
Let me show you.
Discord's a great place for community, for sharing information with each other. The types of things that you can't do on like typical social media or like, in a YouTube chat or any of that. We have Discords for Webb and Buyer with thousands of people in there talking about things.
Webb has a Discord, yep. And
Webb
Buyer,
and Buyer,
yep.
yeah. We met in the Webb Discord. You came to our first like live stream in there, and that's where we discovered
Amy,
you.
I'm going to show you what I mean. Yeah, everyone can talk. First of all, you can talk voice to talk in the messages, so that voices come out instead of just text. But also, there's a voice chat. So the way you would get in, discover creator, you'd go and choose your favorite creator. For now, it's just us. Any tier you want, doesn't matter. The one that we all get together weekly on Wednesday is the $10 tier. You can do camera, voice, nothing, just sit and listen. $5, you can do the same. And we also do some random events where we all get together as well. But this is what the Discord looks like. So try not to get too confused what I'm going to show you. Just keep it easy. Discord, and then this is what it looks like. So I'll just put it full screen. So I can't really zoom in much here, but it shows like all the welcome page. So everyone who's joined, they get welcomed, and then all the announcements. So like my YouTube videos get dropped here by a bot. All my X posts get dropped here. So these are all announcements, IG posts, event announcements, when and where I'm going to be somewhere, intel on certain things. I drop music here sometimes. And then the public chat where we're all kind of talking. Yeah, someone's messaged me. I'll check it out. But yeah, this is the public chat. We all talk in here. But then you can join the group chat and the voice. And then so if I go to the voice chat, I could turn my camera on. If I don't have dual camera on, so I can't. But anyone can join me. Like right now, anyone could join in here. And y'all could come and talk and hang out. So that's Intel voice chat, and there's multiple different. There's a stage where I would be on stage and I could bring people on stage, and it's less of everyone talking, more of a show. So
Yeah.
there's a variety of options. Yeah, it's dope, and ClubVatra keeps it so that we're protecting the audience from just from people that if you're not careful, we've all seen it with Barron, with Coach Colin, and I've seen it in my own discords in the past. If it's just open to the public, even if it's free and it's like a little if it's open to the public and it's very easy to access, that's when you get bots, bad actors, people trying to sabotage, chaos agents. I mean, it even happened. That's why I put a gate on my Discord, and I decided to build this site instead of giving Patreon all the money, because they don't provide much.
Yeah, it's a lot. The only other way is if you have awesome and dependable moderators. We have 3 on both of our Discord channels for Webb and Buyer, and they work tirelessly to keep all of those bad actors at bay. But having something like ClubVatra is actually really awesome. Yeah. All right. Well, hey, let's talk about something. No, I'm very, very proud of the Webb app and the Buyer app. If you don't know, Buyer is our grocery app where you can scan any product in the grocery store, and it'll tell you who owns that. So you think you're buying from Burt's Bees, but really it's Clorox, right? Like that sort of stuff. We help you with all of that. Tons of new features coming. Super stoked. But yeah, we're just trying to build tools for truth and all that. And Ian Carroll is deeply involved in all of them. So shout out Ian Carroll, shout out Buyer, shout out Webb.
Shout them out. All right, I'm going to wrap up shop. Thanks everyone for joining. Thanks for all the contributions. Thanks for showing up. I appreciate it. And follow Kevin. Yeah, we'll see you guys soon. I'll see you in the morning. Saturday, if you're not a member, become 199 cents in YouTube. Members only live stream.
Oh, and we got to do the AI. Everybody keeps asking us to do an AI building stream together, like members only.
We should do it in the Discord.
Yeah, we should do it. We should do that like sometime in the next couple of weeks.
I'm down. Sounds good. All right, cool.
Thanks
See
for
you
having
guys.
me.
Thanks,
Peace.
brother. Peace. Check it out later. See you guys.